Chote.
Mr. Vice President, thank you for the opportunity to speak on this miscellaneous provisions bill. I did my quick calculations and I realized that I have 32 seconds to speak on the amendment for each act. So I think it follows that, and I do look rather accusingly at the leader of government business as I say so, since it means that I have to cut short what I may have to say with respect to some of the proposed amendments, but I will try to do my best. I will not be able to address everything that I can, but I will certainly try to address as many of the things as possible. Now, it could be, I'm first looking at the electronic payments into and out of court amendment, which is to be found right at the back of the proposed bill. It's at section clause 37, amending section 14.2. And I'm afraid I couldn't find the amendment that this was supposed to be applying to, because it was talking about 14.2, but the 14.2 which I was finding on the laws didn't contain the word required. So perhaps this is just an error in numbering, and maybe it is somewhere else in the legislation. Secondly, Administration of Justice Indictable Proceedings Act. Well, I have quite a bit to say about this. Now, I think the impression is being given that since a shutdown for COVID-19, that the electronic systems which have been put down in the judiciary have been working well, and that cases are being processed as usual, or at least with minimum slowdown. I place this on the record that in a notice sent to the Law Association, to all attorneys registered with the Law Association, it ought to be noted that unless you are contacted by a court as a litigant, or your attorney is contacted, and unless your case deals with domestic violence, maintenance, custody, or the proceeds of crime, then your matters have been adjourned by notice. And some of these matters, and this has been going on since the 17th of March 2020, some of these matters have been adjourned as far as the 16th of September 2020. Now, we heard no data from the Honorable Attorney General with respect to these amazing successes, which presumably have occurred using electronic systems. Let me speak as a practitioner. If you are doing a case in the Court of Appeal, that's fine. Electronic systems work well. If you are doing a case where your client is remanded in custody, it depends on the prison. In one prison, it is a container, which is the room where the prisoner is simply held. There is no indication that the prisoner can hear properly, and certainly there is nothing put in place for you to speak to the client, because everything is live. It's done in the presence of a prison officer. So there is no possibility of speaking to your client. So I have had the experience of appearing before a judge, before a magistrate, and also before the Court of Appeal. So I can say that while we have the impression that all of these things were rolled out and they are working well, they are not, at least from my point of view. And if other practitioners disagree, well, then that's their opinion, but that's just the way I see it. With respect to normalization, a stakeholders meeting was proposed only last week for return to the courtroom. And I suspect we will realize that courtrooms in the first place were in an unacceptable state. And this is why it is increasingly difficult for us to return to the courtrooms post-COVID. Now, electronic filings. While we are made to believe that electronic filing is all that it is, there are some instances where you can file documents on the platform used and instances where you can't. So, in a probate application, if you have filed your application, if you need to put in a supplemental document, you can't put it in on the same application. Don't ask me why, but I'm just telling you about my experience as a practitioner. So it appears as though, I don't know if it is one system that is being used, one platform, but certainly the outcomes seem to be different for different departments of the judiciary and for different courts. For the magistrates' court, at least in Port of Spain, what you will find, and I am able to speak about this because many of the persons who spoke on behalf of the government have spoken as if the electronic system is working well, and this is just to tweak it to make it work even better. Not so. I can personally say that magistrates are allocated particular periods of time. I had the really embarrassing situation of appearing before a magistrate on a certain occasion, only to realize that the poor lady had run out of her time and the other senior magistrate was already on screen. And that was as far as we could have gone for that day. So it appears as though magistrates are using one, I suppose, electronic room for the hearings. Surely that is not good enough in a courtroom where you have 11 courts on average with cases to be heard. And this is at the end of COVID. So this is happening after we started, after the shutdown, March, April, May. We are now at the end of June. So those are my comments with respect to that. I am afraid that I have to disagree with the minister in the Ministry of Finance, with whom I like to agree. But unfortunately, I can't join her in the praises of the system as it exists because I've actually experienced what happens under it. I want to refer in particular to what is contained at page 46. It's clause 35, and it talks about the insertion of a clause 4, proceedings under this act may be held by means of a video link, and the record of the proceedings shall be in accordance with the Recording of Court Proceedings Act. Okay, I think as it stands now, proceedings in some cases may be held by video link with the consent of the person, the accused person. And some of the accused persons have not been consenting simply because of the distance that they feel from their attorneys at law who are physically not present, who are not able to advise them, and so on. And this would allow a court to say, in spite of your failure to consent, we can go ahead and have such a hearing. And I don't think that that is right. I think this may affect due process. I may be wrong, but that is the situation. In addition to which, it refers to the Recording of Court Proceedings Act. That's basically like a one-page act. And all it says is that what is recorded The audio transcript of what is recorded shall be certified, and this shall be the record of proceedings for the day. This doesn't cover what happens, let us say, in a criminal trial where you have documents for prisoners to sign and so on and so forth. So this really doesn't do much more than to take away the ability of the accused person to say, I would prefer not to have my case heard by video link. And it doesn't put in any other protection therein. Now, if I may move very, very quickly. If I may move to page 19. Sentencing Commission Act, Clause 6, deletes the word Chief Magistrate. Well, poor Chief Magistrate, I can't see why the Sentencing Commission now shouldn't send its reports to the Chief Magistrate. The magistracy does half of the sentencing within the judiciary. And do we really need to have legislation to say that the Chief Magistrate shall not receive a report from the Sentencing Commission? I find this to be entirely unnecessary and not for the public good. Secondly, this is followed by Clause 7, referring to the Judicial and Legal Services Act. It seems as though the intention is to remove the Chief Magistrate's input and instead have the Court Executive Administrator play a role in this. Now, the Honorable Attorney General spoke about this in his opening, and perhaps there's more to say when he wraps up. Sentencing Commission, as I understand it, is an independent body. True, it may liaise with the Judiciary's Educational Institute. That is expected. But the idea of the institution harmonizing with any group within the judiciary or out of the judiciary, I think is entirely misconceived. So I would respectfully like to know what was the thinking behind considering an independent institution as now having a member of the administrative staff of the judiciary, I suppose, as its liaison. I'm not sure if that's what I understood the Honorable Attorney General to be saying, but certainly I see absolutely no role there for the Court Executive Administrator. No role for the Court Executive Administrator in the Sentencing Commission. At the end of the day, the Court Executive Administrator sentences nobody. So let us, in our rush to get through this piece of legislation brought late in this session, and which allows 29 seconds for discussion, let us not miss points which are important and which need to be said. I'm not here running for office, and I'm not here seeking favors from anyone when I make these points. Now, page 23, I beg your pardon, page 21. I see now that we are allowing the magistracy registrars to fix and grant bail, and I'm not quite sure how this will work, because it would mean that the official who is supposed to be approving the bail is now being allowed to grant bail and to fix bail. I think that there might be an error there, or some sort of conflict of interest. I don't know, but perhaps we could look at it a bit further, or there might be an explanation as to why that is considered appropriate and reasonable. 23, Clause 12, it talks about where the accused person is committed for trial and he's in prison, and the warrant of commitment has to be sent to the prison. May I respectfully just suggest that we should have a time limit on this? And that provision should be made, if need be, because I didn't have time to look at this properly, if need be, for him to make the application for bail if the offense is a bailable one at the time of commitment. Now,
Senator, you have 5 more minutes.
thank you. Right, Mental Health Act. Page 11, I think it is. It talks about a representative of the judiciary being included in this in clause 16. And I disagree. I will move on very quickly because of the things I want to say. Court locations are now designated locations. It seems to me as though this has to be read very carefully because it means that we are talking about court locations as opposed to courthouses. Are we going to have less courthouses? If so, say so. Don't try to do it by sleight of hand. Some of the instances, some of the people who normally go to the courthouses, moneylenders, pawnbrokers, dealers in precious metals and stones, old metal and marine stores, people who go for licenses for cinemas, registration of clubs, theater and dance hall acts, all of these people are now covered under the Municipal Corporations Act. So is it that they are being taken out of the context of the magistrates' courts? And if so, is there a separate body which is being formed in these municipalities to deal with these licenses? Now, the electronic payments, I know that there has been, well, I understand that there has not been consultation with the Law Association of Trinidad and Tobago on these matters. I also know that there had been some sort of issue about electronic payments or the use of the court pay system for the payment of fees by lawyers, practicing fees by lawyers. I don't know if this has been resolved in any way or whether this legislation, this proposed amendment, is a way to avoid dealing with the Law Association's concerns and simply legislating for it. As I say, there is not enough time for me to discuss this during the allotted time period. It is just too much. I simply ask the question and hope that the Honorable Attorney General, in his wrapping up, may be able to provide some clarification and also some statistics as to how the court cases have been running since the start of COVID. I agree. I don't think that this wide power should be given to any Chief Justice to move matters from court to court because that allows allocation by choice instead of the direction we've been going in the High Court, which is to say via the docket system, where you have an electronic system which you have the algorithms work out who is going to get which case. So I don't see, if we have that operating in the High Court, why we should be widening the power of the Honorable Chief Justice or any Chief Justice to move cases in cases which have needed to move in the past, like partheard matters before magistrates. These have been moved by the magistrate himself or herself making an order. It's not mind-boggling, it's not rocket science. So I think to effect what we want to effect, we do not need this kind of proposed amendment. Mr. Vice President, I can't start another topic because I won't be able to finish. So thank you for the opportunity to speak.
Senator Diyal Singh.
Thank you, Mr. Vice President, for allowing me to partake in this discussion here today. I must say, 35 pieces of legislation, it's a lot to go over, but it's like piecemeal that I think the Attorney General said he wanted to at least put certain things in place to expedite to get a proper running of some pieces of legislation. I heard certain objections made by some independent senators and also the opposition of certain parts of the legislation. So first I might say, just going through quickly, I would like to look at certain aspects of it. And I would say, I looked at the clause 4E, which tried to introduce 4 new subsections into section 7. And this is actually looking at the Summary Courts Act, where it was mentioned that it empowers the Chief Justice to designate court locations for holding of summary courts. And the Chief Justice has now the ability to transfer proceedings from one court location to another court location. And it also, the new subsection 4.4 provides for the holding of proceedings by video link. And further, a matter held by the video link is deemed to be held in the district where it was filed or from where it was transferred according to the new subsection. So we have realized that the video link is the way forward. We have realized there's the advantages of it. But the danger mentioned, the perception that was mentioned both by my learned colleague just now and also by Senator Wade Mark, was the ability for the Chief Justice to just transfer from one court to another. In the past, we have seen during the trials of the attempted coup, there was a court set up in Chagaramas, in the Chagaramas. So we have known that courts could be transferred, the power is there. But the fact we have to see is that Clause 4F amends Section 8 of the Act to make clear that the Chief Justice is authorized to assign not only magistrates, but also justices and clerks to a district of court location. So we have to look at, is this really, could this serve an advantage? And I say in certain cases, yes, because sometimes certain courts, the physical infrastructure may leave much to be desired. And for instance, if there's a court where the attorneys complain that it's run down, there may be bats in the ceiling, pigeons, whatnot, you could have that ability to transfer. So there's an advantage. Is there a disadvantage? So again, we have to look, the disadvantage really may be to the individuals that live in that area. Because remember, courts were put in districts so people can have easy access to them. So if you find I'm living in Tunapuna and I'm going to access the Tunapuna court, I would feel a bit aggrieved if I have to leave Tunapuna and go to a court in Port of Spain. Similarly, a lot of the attorneys have their offices close by, so they can attend to that court and see that matter. So therefore, there are disadvantages, there are disadvantages and advantages I see. If the court is really, let's say the court is flooded out, you can move that court location. Video conferences is something that we can look at. However, the problem that seems to arise is the fact that when I look at clause 4J and I, it proposes to amend section 13, authorizing the Chief Justice to also reassign the magistrate or justice in cases where the magistrate or justice is a party or has a personal interest, as well as designating another magistrate or justice to the case. And Mr. Vice President, I thought in cases like this, if a magistrate has an interest in a matter before, he would have declared that interest beforehand and able to, say that I'm not able to sit on this case. So at least this brings into a fact that probably after a case is started, you may have cases where somebody may draw to the attention that the magistrate has that personal interest, because I always thought the magistrate would have that power to would recuse himself in cases like this. So it begs the question is, who determines what is a personal interest in this matter? How do you judge that? How would you now determine that for the Chief Justice to decide, look, I'm moving it from Magistrate X and putting it to Magistrate Y? So taking a case from one magistrate, put it to another magistrate, I guess if there are interests involved and persons raise that red flag, the Chief Justice may step in. After all, he's the head of the judiciary and things have to function under him. However, we should have a system in place where people may not be able to point fingers at the Chief Justice and say, look, you're just moving one case to one magistrate to another magistrate, as was brought up here today. So what I'm saying, sir, is I think, sometimes moving a case from one magistrate to another magistrate, if there appears to be a level of interest, is something that could go both ways. It could go with finger pointing of the Chief Justice and interference. It can go with the fact that some people feel they have a greater degree of being able to, justice in their case. For instance, there's a well-known saying, a good lawyer knows the law, but an excellent lawyer knows the judge. And I'm hoping my colleagues here in law don't look at me in any strange way. But that's a saying that it has. So basically what you're trying to say is that if you do a magistrate in an area, he may influence. He may, just that appearance. So therefore, the fact of rotating magistrates is something that I think is a good idea. The fact that the rotation of magistrates should be in such a way that it could be a number system. There's a list of names, and you pull a number, and there's a list assigned to the magistrate. So no one could actually impute any improper motives to the Chief Justice, because I remember it was in the public domain recently where a certain judge who was assigned to Tobago made a lot of comments in the media that it was unfair and whatnot. So to prevent things like this, there should be a clear case of assignment that you pull something out of the you have numbers that you can pull out assigned to judges and say, okay, you're assigned Tobago, you're assigned South, you're assigned what, and you'll be rotated. And in that way, there would be no sort of allegations or pointing fingers that something is amiss. So I'm thinking having a system like that would, in a way, protect the Chief Justice also from any sort of untoward comments. I also look at Section 19 of the Act, which seeks to amend Clause 4N, which now provides the clerk may sue in the High Court to recover monies paid to the justice or constable that were not transferred immediately to the clerk. And I'm thinking that word immediately, we have to appreciate we are dealing in some times where people may be unemployed, and it's a bit difficult for some people to probably come up with certain monies. So I'm thinking somewhere we have to put something in place where we may have to protect the public who may not have the necessary funds to pay, and now will have to fork out money if they are sued to pay for an attorney fee for that matter. So some system has to be put in place where we could take that into account for the unemployed persons who will have to pay. I looked also at Clause 4P, and Clause 4 actually, P, also introduces a new section 21A, which provides that the court may order such administrative fees as the Chief Justice may determine for the costs associated with the administrative process, such as filing and service of documents, the use of mediation, and the use of interpretation and translation services. Mr. Vice President, a lot of persons would not have money to pay for these. And I'm thinking those services should be offered free. I remember recently reading that a ministry had hired a lot of translators, and I'm thinking those translators should be ones who are given free to the courts, that they would be able to assist rather than the persons involved having to fork out money. Also, paying for mediation services. There's the mediation departments scattered throughout the country. I'm thinking we can have the system where those persons are able to be referred to the mediation department to get free access also for their services rather than have to pay for it. Because, Mr. Vice President, the magistrates often send persons to us at St. Anne's Hospital for psychiatric assessments. So somebody may come to the court, they may behave in a certain manner that the magistrate may be suspicious. He doesn't send them to a private psychiatrist to get assessed. He would basically send them to St. Anne's Hospital, so they get that assessment from that body at no cost. So I'm suggesting that we may have to look at those other services that we can at least tap into without being a cost to the persons out there. I also look at clause 4R, which replaces section 38.2, and I'm saying that actually it's one where it shows that the contents of the statement of an offense, which must be listed, like the name of the offense, the reference to the law creating the offense, and a short description of the offense. And again, this is much needed, especially in the sense that sometimes we have cases go to court, and the police officers may put the offense there, which may not really exist in law. And sometimes the education, the continued education of the police officers, and also ensuring that whoever puts those offenses as part of the statement of offense would put the correct one. Clause 40 seeks to amend section 56 of the Act, allowing the court to transfer a case from one court location to another in the interest of justice. So then, that term, interest of justice, I need to know further clarification, what is the interest of justice? Because we have had, even in this Parliament, where persons may have said that certain attorneys rather to go before certain judges in South and try cases. And, when things like that come about, we have to be sure that we put clear guidelines in place where nobody can point fingers, that we are moving a case to choose our judge as it may seem, or to get away from that aspect. We have to get clear systems in place where nobody would feel that they are aggrieved by that. Clause 5B inserts a new section to section 3, which allows the Chief Justice to designate locations for holding the courts for the hearing of a specific type of case by court. And I'm saying certain cases, we have seen high-profile cases, the whole of Port of Spain got locked down sometimes, and sometimes it may be in cases like this, with very high-profile cases for the security and preventing the lockdown of certain areas in Port of Spain, to move, move cases. And I see that is a positive thing that could be done once proper guidelines are made. Clause 5 also repeals Section 5 of the Act, which details the office hours of the court. I remember years ago we always heard about night courts and all these things. And now I'm saying that now with the Attorney General providing us with more legal members, more judges, more masters, more magistrates, probably the idea of night courts would not come into place again, because we have been promised more courts, and we have seen more personnel came into the judicial system. When I looked at also the Section 17, which provides that a person may sue or be sued in the court of the district to which he resides or conducts business, or in the district where a debt was contracted, a wrongful act was committed, or a contract was made or was to be performed. I'm thinking this opens up the parameters where you can have a matter held, and I see no problem, no objection with this. I look at the Judicial and Legal Service Act, Clause 7 of the Judicial and Legal Service Act, which serves to introduce a new section, Section 15 of the Act. And when I looked at Section 15A, it provides that a senior magistracy registrar and the clerk of the court shall be a justice of the peace and a commissioner of oaths and report to the Chief Justice. So I'm wondering, why is there a hierarchy where the justice of the peace, commissioner of oaths, should now report to the chief magistrate? And then if the chief magistrate now, with the hierarchy, would now, he or she would report to the Chief Justice. I'm wondering why directly to the Chief Justice, if I'm interpreting this wrong, or if somehow the powers of the Chief Magistrate is being taken away, in a sense that you can go straight and not follow that hierarchy going up. I looked at the Defense Act now, where Clause 14 of the bill seeks to allow for the addition of the Air Guard, which is much needed because the Air Guard, I'm thinking, helicopter services, looking at the countryside, looking for marijuana fields, looking at our borders, much needed. But I must say, a lot of our members of the Air Guard, pilots who are trained, are no longer employed. They had to go out and seek private employment. So we have to see how we are going to revamp this Air Guard, even though this piece of legislation there serves to factor them in. Clause 14 also looks at the fact that the President and the Chief of Defense Staff with powers of, they could actually look at an accused in the Defense Service, and if he is charged with a civil offense, somehow get him to remove him from his office. Now, I was a bit alarmed with this because initially I was thinking the Civil Act would
Senator,
be
you have
anything.
5 more minutes.
Yes, thank you, sir. But the Attorney General at least mentioned the fact that this is really criminal offense. So we have to see what degrees of a criminal offense we could remove this person. Is it drunk driving? Is it, using obscene language? What degree? Is it an indictable offense to know that you can now remove a soldier from the army if it comes to that effect? And the clause, there's also in clause 14, serves to bring in a vice chief of defense staff among commissioned officers of the force to assist the Chief of Defense Staff in the performance of duties. I think we have to be a little cautious that the Chief of Defense Staff is not burdened now with a Vice Chief of Defense Staff who he may not agree to, or we are not putting a Vice Chief of Defense Staff in place where we don't have the proper protocols of how they are going to get that job. Probably just as how we looked for a police commissioner, we may have to see if we have something in place for that. Firearms Act and Explosive Act, I looked at the fact that there's an extension of the time, and this is much needed in this COVID time. The clause 17, also the Registrar General Act, looked at given electronic means, and the Attorney General must be commended for bringing that electronic means for payment and whatnot. The Registrar General will not be open, will not be open for transaction business on Saturday, Sunday, Carnival, Monday, and Tuesday. Mr. Vice President, sometimes people have relatives who die in the hospital, and they are not able to access the death certificate on time. And this is something that happens to a lot of people because you can get a temporary death certificate you can get a death certificate that you may be able to the Muslims who die and need to bury their relatives quickly, they have a way where they can get a temporary sort of a certificate. They can bury their dead very quickly. On Monday, they can go into the office and get that certificate of death. I'm thinking it's unfair to the other religions that they may have a relative who die and are not able to access this, and it should be also given to other persons who will want a certificate, or we open the district registers open it right through Saturday, Sunday, so people can access that and bury their loved ones. I looked at the fact that the Hospital Tribunal, clause 23 of the Act 6 to amend section 16 and 17 of the Mental Health Act to allow the Chief Justice and not the Chief Magistrate to appoint any persons to represent the judiciary. I am a member of the Psychiatric Hospital Tribunal, and I had good relations with the Chief Magistrates who were on board. We went and toured the hospital, we saw the atrocious conditions, and it was beneficial for the Chief Magistrate to see what exists, so when the magistrates are sending persons to St. Anne's Hospital, they would know what they are sending them for assessment. I also look at a child who, clause 24 of the bill seeks to amend section 25B of the Children's Act to correct the reference of sexual communication with a child instead of sexual grooming. So we had a recent report in one of the, I think it was in social media, where somebody made allegations about a priest in Mount St. Benedict. Even right now in the Philippines, there's a big case going on with a 4-year-old. We have to ensure that whatever we have in place, it's wide enough to be able to Even if people make inappropriate comments to children, bring them in. You see, sexual grooming has parameters to be made according to the law. And I'm thinking if a man just tell a girl she's sexy, or when you get older, I'm going to be with you, those are things I think we need to bring into law. So I thank you, Mr. Vice President, for me.
Senator Haynes.
Thank you, Mr. Vice President. I thank you for the opportunity to contribute on this debate on this miscellaneous bill brought before the Senate today. Those of us, Mr. Vice President, who've been here for the May-June period in Parliament, we're quite aware of the mad rush before the parliamentary recess, which legislation comes before us and we have to complete an agenda very, very quickly. This one is a little unique. I echo the sentiments of my colleagues who've gone before me, because not only are we coming to parliamentary recess, but we're coming to the end of this particular parliament. Mr. Vice President, this particular piece of legislation, while I understand and appreciate that there are a number of administrative changes and the tidying up of administrative things in the legislation, it still does give us the feeling of rushing down an exam right before, in the last 5 minutes of the examination time allotted. And so you scramble to put everything down on the paper to say quite simply that you've answered all of the questions. I assume, Mr. Vice President, that a lot of this will form parts of the achievements as persons speak about what they've been able to accomplish in 5 years. All well and good. The population is an educated, sensible population, though, so we'll see how far that goes. I want to center my comments, Mr. Vice President, and I appreciate the work that my colleagues have been able to do to bring a certain sense of appreciation to the clauses that are housed in this bill and what they would mean for citizens of Trinidad and Tobago. I want to look quickly at Clause 17, which is the amendment to the Registrar General Act. And this is the bit that deals with electronic payments, Mr. Vice President. I start here because I listened to the Minister in the Ministry of Finance and Minister of Public Administration, who, as well as the Minister of Trade. And while we all agree, I am certainly all for electronic payments and moving to cashless systems. While preparing for this bill and looking at this, and while we can, at all levels, laud what it means to move to electronic payments, the COVID-19 situation also allowed me to reflect on what we see. Those of us who sit in this room, and I found out when, and Senator Sobers can back me up on this, when we were dealing with persons who had to access the salary relief grant, Mr. Vice President. In that process, you were asked for your banking information so that your salary relief grant could be direct deposited into your account. It was at that moment that I realized how many citizens of Trinidad and Tobago quite simply did not have access to not only bank accounts, but can't make use of this electronic payment because they aren't parts of the system. So while we talk about the leaps and bounds that we can move to because of a pandemic that has forced us as a society to move forward, we can also discuss how we can improve accessibility and how we can move towards a more inclusive society, not leaving anybody behind. Now, I appreciate that while fees are now available to be paid electronically, it doesn't remove the cash system, but I just saw it as an opportunity to raise the issue of how many persons may be left out. Madam President, again, while we seek to, in my mind, when you're bringing a miscellaneous bill or any omnibus bill, you should be able to group things and house it in a manner that it would make it easier for us to comment on, so that you're not jumping from one thing, which is electronic payments, to Clause 11, which deals with changing negative resolution to, no, to putting it to negative resolution from affirmative resolution. You see, those things don't connect, because if on one hand we're talking about, okay, improving systems and whatnot, and then in here you have a clause like clause 11, which reduces parliamentary scrutiny in a certain piece of legislation. You see, it comes across disingenuous. It comes across that you're trying to sneak something in a wider piece of legislation. That may not be the case, but I'm saying perception matters. I want to look, Madam President, as well at the amendment to the Motor Vehicles and Road Traffic Act. And I'm looking specifically at the, what is this? 25C, 84B1, a child who is referred to a child trafficking counseling program under this act shall attend the program. I would like, I don't know if the Attorney General will have the time in the wrapping up of this piece of legislation, but at some point in time, to get some details on what this child traffic counseling program would look like. I would say it's a good idea. But it will hinge on its implementation. That's how we'll know if it's effective. Because to put it into legislation, like I said, in a big piece of legislation, to say a child who's referred to a child who's referred shall attend a traffic counseling program. We need to find out. The details of these things are important, Madam President. Simply, was it timeline for the setup? So we pass the law is assented to, and then do we wait 2 years, 4 years for the program to be done? Is the program already complete, ready for rollout? Who is responsible for setting up the program? Is it the Children's Authority? Is it the motor vehicle? Is it the, well, it's not DMV here, but is it people responsible for motor vehicle and traffic? Who is responsible for setting up the program and then ensuring that, because we do know, Madam President, you get your license at 17 in Trinidad, and you're allowed on the roadways. We do see a number of accidents happening with persons in a certain age bracket, whether it is maturity level or what, we do know that's a fact. So I think that this program can have a lot of benefits once it's not just included here to be checked off as a box to say we did something and it's not done effectively and it doesn't meet its good intent. Madam President, I listened to the Minister of Trade talk about a number of the measures in here would improve efficiency and the ease of doing business, looking specifically at Clause 29, which amends the Companies Act. And in 2012, Madam President, out of 190 countries, I believe, Trinidad and Tobago was 63 in terms of the ease of doing business. Today we stand at 105. What that particular statistic tells us is that we absolutely need to do all that's in our power to reduce bureaucracy and red tape so that persons can find it easier to set up a business. Things like company names, just the act of setting up your business needs to be easier. It needs to be more user-friendly. And that we absolutely need to, when you look at the legislation in and of itself, is not enough, but rather the implementation, because the statistics is telling us while we may be passing more and more laws, we aren't being as effective because the numbers are telling us that we are now in a worse position than we were before in terms of the ease of doing business. Madam President, those were the clauses that I looked at specifically. I mean, I looked at some of the others that were commented on before, and I would add to Senator Choate, I want to just add my voice to what Senator Choate said, which is this idea of the expansion and power on any Chief Justice that needs to be looked at carefully and ought not to form part of an omnibus bill in this nature. So if you were to just take that out, and I understand what the Attorney General said about efficiency, but let's be sensible about it. Let us group them in a way that if they're only merely administrative, we deal with that, and those that deal with the expansion of powers, etc., deal with those on a separate day. And that's how we will be responsible legislators. And I thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Thank you. Thank you very much, Madam President. Madam President, I'm happy for the opportunity to speak on this miscellaneous amendments number 2 Bill 2020, mainly to address what is proposed in clause 26, which is 2 areas of amendment to the Conservation of Wildlife Act. Madam President, the main piece of legislation that deals with wildlife conservation in the country. Madam President, just to trace the history a little bit, upon my appointment in September 2015, there was in place a moratorium on hunting, which meant that for the 2 years previously, there was no hunting in Trinidad and Tobago. Madam President, it is well known that I come from southeast Trinidad. A significant amount of hunting takes place, and hunting is a major economic activity during the hunting season. And I have been cast in the role of a supporter of hunting. And I always have to be very careful to point out that I'm not a significant consumer of wild meat. I've spent a significant part of my life as a vegetarian. You may be surprised. But as a minister responsible for meat, I resumed consumption of meat a few years ago. But I understand, having grown up in these communities, the significance of hunting. But I also understand, Madam President, from the outset, that I'm here as a minister to represent not my interests, to balance the interests in the society, and to make sure that conservationists and environmentalists understand the economic importance of hunting, but also to make sure the hunters and the poachers understand the need to follow the law and also to behave in an appropriate manner. The irony of it all, Madam President, having said all of that, is that I believe I'm the minister who has made the most significant changes to the hunting regime in the country, not by anything major. The Conservation of Wildlife Act remains substantially the same, but I've focused together with my colleagues in the Cabinet and my colleague, the Honorable Attorney General in particular, on the regulations to see how we could effect small but significant changes. And on one occasion previously, the Conservation of Wildlife Act itself, because it is in the body of the Act that the fines are contained. There are some fines in the regulations which the minister can change by order, but the major fines are in the Conservation of Wildlife Act. And to just satisfy Senator Haynes, this is not a run-up to the election. There is no hunting of significance in Chaguanas East, except the hunting of my UNC opponent, who is still undeclared. So this is not for campaigning for me. I am set, and I know you know that. This time around, my slogan is time to win. Not that I'm unhappy serving in this house, but I'm good with my time here. Madam President, in November 2015, we commissioned a consultation with all the interests in wildlife and wildlife conservation and environmentalists. I must say I was quite surprised with the turnout and the discussions and the appreciation of the issues. And out of that consultation, a report was developed and a steering committee was appointed to review the report. And out of that, in September 2016, at my first year anniversary, I presented to Cabinet the report outlining some of the changes that should be made to the management of wildlife in Trinidad and Tobago. And it was not my work. It was the work of the hunters, the conservationists, the environmentalists, overseen by the Zoological Society of Trinidad and Tobago, and in particular chaired by Naja Natai Gan, who is the current chairman of the EMA, and guided by my predecessor, former Minister Mohammed, who has done an excellent job in his work on wildlife and other things, Dr. Riza Mohammed. In October 2016, a Wildlife Conservation Committee was appointed in accordance with the Act and was given a mandate by the Cabinet to do a number of things, including improving the hunting regime and the conservation regime. Out of that, Madam President, one of the most significant things I think the committee, together with the EMA and Forestry Division of the Ministry, have done is to move and complete the work to have the scarlet ibis, our national bird, declared an environmentally sensitive species. And it was startling that we could have given that protection to so many deserving animals in the country, but not our national bird. And that protection is in place. We have a few matters before the court. And I keep saying, as minister, I would really like to see somebody having to pay that significant fine. We've also taken steps through the EMA and through the ESS process to put in place the ESS designation for the red howler monkey and the white-faced capuchin. Madam President, in January 2019, we made the first move to significantly increase the fines through the Finance Act. And those increases were from $200, could you imagine that, up to 2019 for these offensive crimes to wildlife, including impeding an officer in the execution of his or her duties. The fine was as little as $200. Madam President, at that time, in working with the Honorable AG on the increase in fines, the general view was that the fines should be increased to the range of $50,000 to $100,000. And I felt that we should give the fraternity an opportunity to guide their own affairs. And we ended up increasing fines to a maximum of $10,000. Thereafter, we increased the fines in February 2019 under the regulations, which the minister could do by order, once the fines are up to a maximum of $10,000. In March 2019, through regulations, I made some significant changes with the support of my colleagues in Cabinet to the hunting regime, particularly this habit we had of hunting birds and waterfowl and ducks. And Molly Gaskin and Carolyn Shepard have spent a significant part of their lives advocating for the protection of what is described as the wildfowl. Trinidad is an important destination for migratory birds out of North America during the winter. We have been under pressure from all places to preserve these birds when they come here. Up in the river swamp, I could say personally that hunters would go. There is a special period for duck hunting, and hunters would go and do target practice on the ducks. You know, in our community, when we shoot to eat. You don't shoot for sport. You shoot to sell. And it was sad to go up there and see the type of guns being used and the fact that even after 100 ducks were down on the ground, the people just turned around and packed up and went home. So this was not hunting for food. was hunting for sport. And I just felt as a minister, in consultation with the community and my colleagues, that in the river swamp and the Godino River and those places where we have ducks should really be environmentally friendly, family-friendly, quiet places. And we took the decision to ban all forms of duck and bird hunting in the country, with the exception of one or two. One that remains on the list is the Kobo. And I did not think that we had so many Kobo fans in the country. I am personally a fan of the Kobo. But there was an outcry afterwards for me to include that, which I have not done. We've also focused heavily on enforcement. And Madam President, I must say, the police officers and the Coast Guard, National Security, our game wardens, have taken significant interest. They recognize the proliferation of illegal game and trafficking in wild animals coming from South America. And every so often, quite often, you see me post on my Facebook page some of the work they've done. In fact, last week, a magistrate charged somebody, if you never hear about clipping the wings of a bird being an offense. Well, somebody was charged for that, amongst other things, and has 3 months to pay a fine of $93,500. You see, persuasion is one way of getting people to do the right thing, but sometimes the fine has to be set in such a prohibitive way that we force people to do the right thing. And while I support some level of hunting, and the government supports that, we also believe that it should be confined to the hunting period, and it should be done in a reasonable way, so that we strike a balance between the animals that are forming part of the ecosystem and should remain that way, and the need for some people, particularly in rural communities, to be able to earn a living as they have done for centuries out of hunting. So, Madam President, what is proposed, and this is to bring the Wildlife Conservation of Wildlife Act in line with what was approved in relation to animal welfare when the previous miscellaneous bill, when we amended the Summary Offences Act to increase the fines for animal cruelty to $100,000. The bill that was passed, which I call the Animal Welfare Bill, which is to be debated in the other place on Wednesday, where the fines are in the range of $100,000 and $200,000. And this is to increase the fines in most of the categories to between $50,000 and $100,000. For the most significant offenses, up to $100,000, to give the magistrate, in those cases where the magistrate believes that it warrants that sort of fine, to give the magistrate the discretion to go up to that amount. The second area of amendment, Madam President, is in this Wildlife Conservation Committee, which I have said before has done excellent work in service of the country. But what I've found, Madam President, as a minister, is that the composition of the committee was determined in the legislation such a long time ago that the area of conservation and environmental action and veterinary services and all those things has evolved in such a way that you have a lot of sub-professionals and some different classes and skills that have developed. And I've found that it is too narrow and prescriptive in the current context. We should have a broader representation, and we should have the opportunity to do that. But most importantly, Madam President, the Wildlife Conservation Committee is meant to provide advice to the minister, because it is very rare that a minister would come in and have responsibility for wildlife conservation and at the same time have that level of expertise across a broad scale area. And for that reason, some pieces of legislation, including this one, provide for advisory. Recently, we did a Save Animal Welfare Bill, the Animal Diseases and Importation Bill, and we included an advisory committee recognizing that a minister would need to have that sort of independent technical advice. The one constraint, Madam President, with all due respect to the current and previous office holders, is that this committee by law is chaired by the Conservator of Forests, and I believe it is something like himself advising himself. So the change that is proposed is to expand the committee from the current number, to increase the number to 10. And I would say right away, we've heard from some senators that they wish to have a further increase in the number, to recognize in particular, to specify representatives from the vet fraternity and also specify from the environmentalist group. And I've spoken to the AG and we are in agreement with that amendment, expanding by the addition of two further members to represent the vet profession and the environmentalist
Minister, you have 5
fraternity.
more minutes.
Thank you, Madam President. And so the key changes would be to expand the membership of the committee from the current 9, and we propose the conservators and ex officio, an additional member, 10. So it's 10 plus the conservator, and we're prepared to go to 13, and also to expand the skill sets of the persons to be selected. So we still prescribe, Madam President, a member of the Zoological Society. We still prescribe a member to represent the Trinidad and Tobago Police Service. We prescribe 2 members to represent wildlife hunters, and Madam President, one senator has asked me why we have 2 representing hunters and why not 1. And I said, without going into the details, which will take me my next 5 years in office, that the hunting fraternity is not as united as that, and this allows us to choose from 2 of the large groupings, which basically represent the South and the North farmers, hunters. And you see, I'm not looking after the interests of central hunters at all. So that is prescribed. And then at the proposed 26E, Roman 2E, we propose 5 members to be drawn from animal health and welfare, wildlife conservation, forestry, community service, and law. And that allows if a minister to be able to put together an advisory committee from a broad cross-section of professionals in the country to be able to advise on something as significant as this. Madam President, as Minister of Agriculture, Land and Fisheries, a lot of people, one potential appointee to the post described it as pumpkin and budgie. It is more than that. It includes a lot of things, and one of the things it includes is responsibility for wildlife in the country. A lady asked me this morning about the proliferation of iguanas in the city of Port of Spain. And I reminded her that one of the things we've done is to ban the hunting of iguanas in the city of Port of Spain, not because we love iguanas, we all love iguanas, but because it represented a major national security issue for persons living in places like Cascade and St. Anne's who would wake up and see people hunting in their yards. And I believe that that small regulatory change has kept the peace in urban Port of Spain, and is something the government has said we're prepared to do in other parts of the country. So this addresses a small part, but important part of my portfolio, Madam President. And as I demonstrated, we've been at work doing it since November 2015, and this is another piece of the work we have to do, and I thank you very much.
Senator Obika.
President, I wish to start where the Minister of Agriculture left off. It has to do with the Conservation of Wildlife Act. Before I get into the somewhat unconnected pieces of legislation, I think many times we come before the Parliament and we recognize attempts to curb negative social behavior by virtue of using fines, custodial sentences, and so on. But to me, in the Conservation of Wildlife Act, we are presented with an opportunity to not only look at fines, but payments to persons. Because if you look at what we use in fighting crime, for instance, Madam President, we do have fines, we do have custodial sentences, as in jail time and so on, community service and so on, for the offenders. But for the informants, we have the 800 tips, for example, where they can receive cash payments for informing the protective services of alleged illegal activity of one kind or the other. So if we are saying that in the Conservation of Wildlife Act, the fines of $10,000 and $1,500 and $4,000 for different offenses were unsatisfactory in curbing attempts at exterminating some species of wildlife in Trinidad and Tobago, and we raise it to 100,000 and so on, we may ask ourselves if maybe the detection rate or the apprehension rate is not significant, if these fines would really redound to the benefit of what this law and the amendments are trying to do. We may ask ourselves, there may be the opportunity to present payments to persons, because many persons may know of individuals engaged in trafficking, capturing, and exterminating wildlife, whether it be the national bird, the scarlet ibis, on one hand, or the deer in the forest. If persons have an opportunity to earn by virtue of successfully informing the protective services, we may find that we'll be more successful in conserving wildlife. And whilst I may not have an amendment on the floor, I wish that this falls kindly on the ears of members opposite in government, so that they can seek to contemplate payments to persons, rewards to persons who so inform the protective services.
Friend would give way just
Yes,
to point out that in the Conservation of Wildlife Act, there is a provision, Section 21 provides for 50% of the penalty to be paid to anybody who is given information. So it means that by raising it to 100,000, the fine, there's an opportunity for somebody who has provided information to get as much as $50,000. I could say I have no control over the judiciary. I could say in my time as minister and for years before that, I am not aware of any magistrate who has directed that part of the fine be paid to an informant, but it is provided in the law at Section 21.
I thank the Minister for the interjection. I think then, given the Minister's caution in articulating how persons get funds, I think we're on the right path with the legislation, but we should look at presenting a foolproof mechanism such as is in place with 800 tips, where persons feel that they can securely get this money. Because if in the process of getting the funds, you can get an attempt on your life, you wouldn't even venture to participate in informing the state. So I thank the Minister for that, and I still wish if we can get ourselves closer to the 800 tips model for conservation and wildlife. Now, the Minister made a statement in jest, I assume, regarding Chagonas, but I guess it was in relation to Clause 22 regarding the EBC and the deferral of submission of the report by an entire year. And it begs the question, why? Why now? Especially given the heightened focus on electoral politics in Trinidad and Tobago, given that no regime has served 2 full consecutive terms since the passing of the first Prime Minister. Not a single Prime Minister thereafter has successfully completed 2 full consecutive terms in office. Persons would be focused on the change in government, as we would, of course, advance, but as persons would expect, given the historical political cycle, we would have anticipated that the EBC would have not been an institution to renege on their responsibility at this time. I think the government has many questions to answer regarding Clause 22. I want to say that some of these clauses, when we turn to, for instance, the VAT measures, clause 27, I want to speak generally as to the COVID-19 pandemic, where that may have been informed by. And there's just one statement I want to make on that, is that, and it's from advice I received from a colleague when I was facing a personal obstacle. So I see the COVID-19 pandemic and our economic response as the obstacle that we are faced with as a nation. And I want to say that our legacy in Trinidad and Tobago will be greater than the obstacles faced by this nation in COVID-19. Our legacy will be greater. Saying that, I think the government has missed a vital opportunity, because regarding the amendment proposed in clause 27, one would have thought, apart from looking at penalties or non-penalties regarding the bond payments, we should have looked at the opportunity to remove VAT from the basic food items that we have so conscientiously packed into these hampers that we have given and continue to give to persons who may find themselves in situations where they need support for food for their families. I think that this was an opportunity for that in that case. So I want to go back to clause 17. So in clause 17, it is proposed regarding the electronic payments at the level of the Registrar General, and it raises the question, what is actually in place at the level, at the shop floor, if I were to use that word, at the banking hall, for instance, in the Registrar General office, the different offices there, and generally in any office where you have to make payments to the state, apart from the courts, which have made some changes recently, what systems are in place to receive electronic payments? So I'm not speaking to payments online here, I'm speaking to payments using links or credit card and so on. I think the government would need to explain how far along are we, because in fact, if we aren't far along, we have much to do there, and this measure may not redound to the benefit that we wish. There's another issue regarding online payments, Madam President. That has to do with the security and safety of online payment platforms that the state may engage in. And it would be necessary to allay the fears of citizens so that they can freely and willfully engage in such payments so that there are no issues there. The issue of online payments also raises another question. It has to do with the law as it pertains to electronic payments. And there was, and I want to illustrate by virtue of an example. There's a WePay system, and persons engaged in making payments to support, whether it be persons who need cash support and so on, the organizer of that system, the originator of that system, the vendor, had to go at pains to show that he was not, in fact, using a money transfer or money generating system that did not contravene the laws regarding such in Trinidad and Tobago. There is need to revolutionize and bring into this century the mechanisms available to vendors and to businesses regarding that type of payment system. This Parliament has come to an end, and I would raise that separately with the Attorney General afterward. I see the Attorney General looking to raise a question. I don't have the actual name of the law in front of me. I would raise it with the Attorney General separately. With the Attorney General separately, so you can understand exactly where I'm coming from. But I believe that the life of this Parliament has come to an end, so it may be something that we may have to pay attention going forward. Now, regarding the electronic payments, it also raises another issue regarding the establishment in terms of the personnel and staff complement and the way the job descriptions are are restrictive. For instance, if one works in a financial institution, anyone who is so trained can fulfill the role of persons who are cashing or telling, as they may be. But using the government establishment posts, that may be a little more restrictive and difficult for someone to move their staff around to key positions. And I think the government should want to look at that as well. Clause 24 raises the issue of child traffic violators. And it was comforting that no fine was contemplated. However, what I have a little issue with is where it states that if a child fails to comply with the court is empowered to make the child enter the performance of unpaid work in accordance with the provisions of Community Service Orders Act. I had great difficulty with that statement, you know. And when we go down into clause 25, we see that the traffic counseling program instead was used. And to me, when you say a child being engaged in unpaid work, Madam President, it sounds as forced child labor. You know, it doesn't sit well with my conscience. And I think we should be careful not to introduce that type of directives into the legislation, especially where children are concerned. I think the remedy cited in clause 25 may be more amenable to improving the outlook of children as they are still in their formative stages. Clause 28, Madam President, and I know Senator Marks spoke at length on clause 28, so I only want to raise one juxtaposition. Pleasure, craft. At this time, it raises the question, why? Why is it that important at this time, as the life of the Parliament is coming to an end? Why would we focus on ensuring we insert into a miscellaneous provisions bill without the opportunity for great debate because of the number and the range of clauses involved? Why would we seek to insert that at this time? When you juxtapose that with the unwillingness or the inability to include removal of VAT on basic food items, a wider array of basic food items, it begs the question, you know, is this government really interested in the average person thriving in this country? Turning to clause 29, there are so many clauses to address in this bill that you can only, in passing, deal with them, which I have great issue with. But here we are. It is curious to me that the government would seek to extend the period for reservation of a name from 20 to 45 days. It begs the question if the government is catering to a more inefficient system of business registration. And once you speak to business registration, because, of course, the government will advance the argument that is being requested by business or by persons who seek a little more time to get their names, to get through their name requests and so on. However, if we present the information as to...
Senator Obika, you have 5 more minutes.
Thank you, Madam President. If we present the information as to how many businesses really would have been adversely affected by the shorter 20 days, it may make a case for keeping it at 20 days, because the ease of doing business is very important to how our country projects itself, how we attract investment, and of course, it provides a rigid guide for public officers, servants of the public, to ensure that their systems are efficient in meeting the needs of the customer, of the public. Clause 30, Madam President, speaks to the Moneylenders Act. And one can easily observe across this country an increased capitalization of marquee money lending operations. So I'm not saying that there are more money lenders in Trinidad and Tobago now than before, or less. I'm saying that you can observe that there are some money lending operations that have increased significantly their level of capitalization. And as a result of that, this amendment, if to have been dealt with now, should have taken into consideration that change and not just the administrative change as to what is presented here, but focus more on bringing the money lenders closer to a better form of financial service regulation, so that, of course, clients are better served. Because we still have a lot of money lenders providing loans at rates that are ultra-vires low. And if we bring these money lending operations into closer and tighter, at least the larger ones, regulation, it would assist in better meeting the needs of clients and, of course, a more fair and equitable system in this country. Madam President, I recognize that the life of the Parliament is coming to an end, and this may very well be my final contribution in this Parliament, given that an election date announcement may be imminent. I wish to say that it has been a pleasure to be part of this Parliament. It has been a pleasure to serve the people of Trinidad and Tobago. It has been a pleasure to serve the people of my constituency. And whilst some may like or dislike my fighting spirit, I do it for the people of my beloved country. Madam President, I thank you very much, and I thank all my colleagues on all sides of the bench, of the benches of Parliament. Thank you.
Senator Amin.
Thank you very much, Madam President, for this opportunity to contribute in what may very well be our final debate in this Parliament. The opposition is not in charge of the agenda here, so we can only speculate. Madam President, I am still of the belief that the limited time that the government has determined is suitable for this Parliament based on the COVID restrictions, and given the nature of the bills that are being engaged now, I see a contradiction, and I am not satisfied that the government has sufficient reason to still be shortening the time of members. That being said, Madam President, I want to quickly touch on a few of the clauses and a few of the elements. I want to say elements because I know in a debate it's not always clause by clause, but there are different elements that will be affected. Madam President, I listened to members on the government bench praising some of the measures that we see on paper. The commendable moves of electronic payments of fees to the court, of virtual hearing, and so on. This did not start under this government. Work has been in progress within the judiciary to have these things done, and it spanned over several administrations. The People's Partnership Government embraced the judiciary's efforts in this regard. I am happy to hear from people who are practitioners in the court system, attorneys and so on. So when a legislator could read the administrative measures being implemented, that is one thing. It sounds commendable, and of course the government will pat themselves on the back. Himself to himself, self-praise is no praise. So while the commendations may be legitimate, the contribution and the views of practitioners, when I hear the contribution of independent Senator Sophia Choate, my colleagues Saddam Hussein and Sean Sobers, who are practicing attorneys, we have Senator Vera and others, I think their perspective is very important when it comes to what is actually being practiced in court, what is encouraged, what should be encouraged, and what improvements are to be made. Madam President, I am not a practitioner. So while I commend the direction, I think I don't intend to comment extensively on any of those clauses. Madam President, I want quite a number of the clauses in this bill. It's administrative, and I know that it is more or less, as the Attorney General likes to say, a tidying up of the law. So that's all well and good. This Act deals with 17 pieces of legislation. I want to very quickly go to Clause 4, which seeks to amend the Summary Courts Act to empower the Chief Justice to appoint locations for the holding of summary courts and to designate a court location for the hearing of specific types of cases by a summary court, and to assign magistrates to more than one court location, and to issue practice directions and practice guidelines. Some of my colleagues commented on this, but I wanted to ask a question. The Chief Justice already has the power to designate a summary court. Does this provision merely extend that power from location to include the types of cases? The contentious issue here can be that the Chief Justice, of course, can transfer a case from one summary court to another. My question is, can this take place after a matter is started? Should we be clear here that the matter should not be transferred once it is started, or that provision should be made before the matter is started? That is one question I think we could somehow include, or do we leave that discretion to the Chief Justice? It should state here whether that power cannot be exercised once the matter has started. The provision here is silent, and it may become contentious after this is implemented. We don't want claims of victimization or interference or discrimination of any sort. So my colleague also raised an issue, for example, on what grounds would a matter be heard expeditiously in one court but not in another court? There are inefficiencies in our justice system. We know that. There are courts that are functioning under really terrible situations in terms of their accommodation. Do you transfer from one court because the roof is leaking? Because the air conditioner is breaking down constantly? These things are happening in courts throughout the country. So what do you call, for what reason would you move it from one to another, or is that totally under the discretion of the Chief Justice? Guarding against the possible perception of interference is also very critical. And I want to endorse my colleague Saddam Hussein, who raised that matter earlier in the debate. I now want to go very quickly to Clause 4P, which really deals with the clerk being able to make a payment as directed by the minister, but in accordance with the direction of the accounting officer of the Judiciary. I just want to say, Madam President, as I say, I am not a practitioner, a legal practitioner. But I just want to suggest that this could be confusing. Is the clerk going to be directed by the minister or by the judiciary, by the accounting officer in the judiciary? I think we have to be clear. It can be either or. It can be to the minister, but directed by the judiciary. We have to guard against that separation of power, and I think that is might be minor. It might be minor, but in case in future any confusion arise, I think we have to be clear on it. Madam President, there is also a clause 7, that states the clerk of the court shall report to the Chief Justice. There is 15A and 15B. So in 15A2, a senior magistracy registrar and clerk of the court shall report to the Chief Justice. But in 15B2, it says the magistracy registrar and clerk of the court shall report to the senior magistracy registrar and the clerk of the court. I just want to suggest that there be some consistency so that, we are very clear. Having that inconsistency with reporting to the senior magistracy registrar and the clerk of the court should be eliminated by having the same thing throughout. If you decide it must be and, if it should be both, it should probably be both throughout. Madam President, Clause 11. Clause 11 has an impact on parliamentary oversight. I always speak about and support the importance of parliamentary oversight in our Westminster system. The need for transparency, the need for the Parliament to constantly be able to have that reach according to what is current. So the Clause 11 seeks to amend Section 67 of the Sexual Offences Act to remove the requirement for an order to amend Schedule 1 and 2 by affirmative resolution of Parliament and to provide for those schedules to be amended by order subject to negative resolution of Parliament. We are moving from having those get an affirmative resolution to having a negative resolution of Parliament. To me, this removes the provision that we have now for parliamentary oversight of the executive, and when exercising legislative power, this, Madam President, I feel is something that we should oppose. The Parliament should continue to be able to have that check on the exercise of this power. So I'm not in agreement with moving from affirmative resolution to a negative resolution of Parliament for Clause 11. Madam President, Clause 14 in this bill, part of the clause provides for the inclusion of the Air Guard as a unit of the Trinidad and Tobago Defense Force and to empower the President and the Chief of Defense Staff and so on. But the other part of the clause provides for the appointment of a Vice Chief of Defense Staff. And it says that it would come from amongst the commissioned officers of the force, and that the Vice Chief of Defense Staff shall assist the Chief of Defense Staff in the performance of his duties. What this clause is silent on is who appoints the Vice Chief of Defense. I know that the presumption, of course, will be that the Vice Chief of Defense, or shall I say CDS, because that is they usually refer to it as the CDS. The Vice CDS, it would be presumed, would be appointed in the same manner as the CDS. But it is not stated here at all. I don't think it will be too much for us to say how the Vice CDS will be appointed. I expect it will be in a similar manner as the CDS, But I think we have the opportunity to clearly indicate that here. I see no harm in it, and I want to put that forward as a recommendation. Madam President, this miscellaneous amendments bill also deals with fireworks. It amends the Explosives Act to provide for a license to be issued on the order of a magistrate, to be signed by the magistrate of a clerk, and it provides for the clerk. It provides for the order of a magistrate to be signed by the magistrate of a clerk and for an application to be filed with the clerk and not the magistrate. Let me begin, Madam President, by saying on this point that animal lovers, people who are elderly or affected by noises, have become more outspoken about the use of fireworks. There are advocates who constantly talk about the use of fireworks in Trinidad and Tobago, whether it is necessary. Clearly, there is a nuisance factor. What happens at the particular times when fireworks would be popular. And we do have a present system to grant license for the use of fireworks, but there has been calls for more checks and balances to be put in place. This provides another form of checks, but it might seem minor, but I think it is good. What I think we have to be clear about, Madam President, it seems okay for the magistrate to grant the order and to have the clerk do the necessary administrative paperwork. But what happens when the clerk fails to act in a timely manner? When the magistrate makes a decision and it goes to the clerk for a signature, and you have a delay that could interrupt, having whether you have the event or not, or having the fireworks or not. Further to that, when the order is actually signed by the clerk, is it an order of the magistrate or an order of the clerk?
Senator Mean, you have 5 more minutes.
Thank you. Is the clerk signing on behalf of the magistrate or on his own as clerk of the court? I think we need to be clear that it should be stated that notwithstanding the order is signed by the clerk, it is deemed an order of the magistrate. It may seem very simple, but I think it's important, Madam President. But I think this step may be welcomed by advocates. But I also want to add my voice on this matter to say this is not enough when it comes to fireworks in Trinidad and Tobago and how it affects the elderly and pets, and all of us are the members of the public in general. So I do look forward to more being done with regards to fireworks in Trinidad and Tobago. Madam President, a number of members on the other side spoke about the provision for fees to be paid to the Registrar General electronically. The clause also specifies that the Office of the Registrar General will not be open for transaction of business on Saturdays, Sundays, Carnival, Monday, Tuesday, public holidays, and the next following day after Christmas Day, Tuesday and Wednesday after Easter, and on any day as the Minister with responsibility for legal affairs may direct. I just want to query one thing. It says that the office will be closed, will not be open for the transaction of business. But is it that the office is going to be closed? Is it that they're not open to the public, but the workers still come to work? And if it is that the public officers don't have to come to work on these days, then there is a difference in what happens with other workers in the public service. For example, if you look at, well, I don't know if it's called Easter Wednesday. We are extending this Easter weekend for so long. The Wednesday after Easter is a public holiday, will be a holiday for public officers in this Registrar General's office, but not for public officers. So I think we have to be consistent, and we could just simply say that the office of the Registrar General will be closed for business transactions with the public on those days, but not that it will be closed, because then you are talking about the days the workers will come out, and that will be different from others in the public service. There are a few clauses in this bill that has an impact on local government and regional corporations when it comes to there are six clauses, but Madam President, I want to very quickly say that the fact that these 6 clauses, they are coming up, it was mentioned before in the Cinematography Act and so on before, there is a pressing need for reform of local government in Trinidad and Tobago. I sit on the local government reform committee, the JSC, and work has been ongoing for some time, but this is one of the first things the government spoke about. Several of these issues are mentioned in the 9 pieces of legislation that is before that committee. But I really feel that full implementation of local government reform, if this government was truly committed to reform, could have taken place already in the time since they have been there. So while I am in full support of local government being given more powers in law, I also want to urge that the Present Act is still not fully implemented at this time. The government is in the process of discussing local government reform. It was a campaign promise, and I think the approach is to bite off, I think, 9 or 11 pieces of legislation. Thank you. Some of those that were mentioned here. But, you know, sometimes in trying to bite off more than you can chew, at this time the government is choking. And your time has run out, and you have no good answer for the people of Trinidad and Tobago. Madam President, I just feel this 20 minutes is just not enough to do justice to a bill that has 17 pieces, but I thank you for allowing me to have a contribution.
Attorney General.
Thank you, Madam President. Madam President, I wish to thank all honorable senators for their contributions to this particular debate. I wish to especially thank honorable members for the recommendations that they have brought to the floor for consideration. I don't propose to be very long in the wrap-up on this particular bill, because I believe a bill of this type is better spent in committee stage. And perhaps that's the correct place to start. I want to just remind honorable senators that whilst the speaking time has been adjusted during the COVID situation, and which has worked rather well for all of us insofar as we've been in the position of achieving a great workload, accomplishment, I want to remind that there is no restriction at committee stage. And in fact, it is at the committee stage that we work through the full particulars of concerns of honorable senators in legislation. I personally, having had the task of piloting the vast majority of work in this government, have had no difficulty whatsoever in the truncated time to pilot the legislation. So whilst I do uphold and cherish the principles of freedom of speech in this Parliament, as it is enshrined in our Constitution, I really don't feel much difficulty in the statement of principles and the identification of issues that were permitted in the truncated time frame. Madam President, there are just a few issues I'd like to touch in relation to this law. I regret that I was torn between another meeting, the Finance and General Purposes meeting, and that therefore I missed a few of the contributions in their full course. I do have some notes coming from my colleague, Senator Rambarat, as to some of the contributions. But permit me to address just a few of these issues and then take a very fulsome approach at the committee stage as we go through. Senator Mark raised the issue of the SRC, and also so did Senator Thompson-Ahi. Senator Thompson-Ahi raised the point of the considerations that we ought to have when we were dealing with the amendments proposed for the Registrar General. And I'd just like to deal with that issue first. We do propose an amendment to the Judicial and Legal Services Act. We do that by Clause 7 of the bill. And when we get to Clause 7 of the bill, and we look to the manner in which we propose those amendments, permit me to reflect upon the history of this. I'd like to put on the record that we've sought to be guided ultimately by the Constitution in this matter. The Constitution of the Republic of Trinidad and Tobago sets out at Section 141 of the Constitution that the Salaries Review Commission shall, from time to time, with the approval of the President, review salaries and conditions of service of the President, the holders of offices referred to in Sections 136(12) to 15, members of Parliament, including ministers of government, parliamentary secretaries, and the holders of such other offices as may be prescribed. It then goes on to say that the report of the SRC concerning any review of salaries or other conditions of service, or both, shall be submitted to the President, who shall forward a copy thereof to the Prime Minister for presentation to the Cabinet and for laying as soon as possible thereafter on the table of each House. I also want to put onto the record Section 111 of the Constitution. And it is important to bear in mind that the officers referred to at Section 111, that is appointment of judicial officers, etc., where the Prime Minister is the person that must be consulted. These are the following offices where the Prime Minister has a consultation role. Before the Judicial and Legal Services Commission makes any appointment to the offices of Solicitor General, Chief Parliamentary Counsel, Director of Public Prosecutions, Registrar General, or Chief State Solicitor, it shall consult with the Prime Minister. So our Constitution at Section 111 specifically sets out, and for good reason, the office of the Registrar General. Section 141 of the Constitution says the SRC conducts a review. In fact, we know the process is the President triggers the SRC review. The SRC does a review. The SRC's review is not the say-so. The SRC makes a recommendation which goes to the Cabinet, and only the Cabinet decides what will be the terms and conditions. I want to point out that the SRC recommended in its last report to this Parliament that no parliamentarian, including senators, should have motor vehicle benefits. That those taxation benefits that senators and members of Parliament enjoy should be removed. Obviously, that didn't happen. The SRC's recommendation ran against the grain that you cannot deprive office holders of a benefit without their express consent. But that didn't stop the SRC from making their recommendation. And the matter for the record of the Registrar General, permit me to put this on record. In October last year, the government agreed to the change in the salary positions for the Registrar General for very good reason. The Registrar General, under the workload that we have put the Registrar General, by the passage of the Non-Profit Organization Bill, the Real Estate Agents Bill, the Companies Amendment Act, the Civil Asset Recovery Unexplained Wealth Act, the Electronic Transactions Act, the 4 laws in the Land Package Act, the Registration of Deeds Miscellaneous Provisions Act, all of these things have seen us radically ramp up the workload of the Registrar General. The Registrar General must hold the position of accuracy, assist law enforcement, financial intelligence unit, and the court, Trinidad and Tobago Police Service, Board of Inland Revenue, for all vital statistics: births, deaths, marriages, adoption, all companies and business entities, all land transactions. And therefore, when one has regard for the fact that the Registrar General has 545 employees with offices in Port of Spain, San Fernando, Tobago, Arima, with 16 Registrar General divisions to manage, it is ludicrous, most respectfully, for us to sit and watch the Registrar General not achieve the terms and conditions of a chief legal officer, particularly when the CPC's department, SG's department, the Chief State Solicitor's department, and the DPP's office all have by far less volume to manage, not severity or sincerity of work effort. And if we are serious about meeting muster, efficiency is an important requirement. So most respectfully, I think it entirely in order for a government to act within Section 141(2), Section 141 of the Constitution, to adjust the terms and conditions as the Cabinet is entitled to do. Because the SRC's position since the year 2002 has been wait until it's done. We are in 2020. It's been 18 years. If you couldn't do it in 18 years, when are you going to do it? So most respectfully, I think this position entirely in order. With respect to electronic transactions, I'd like to put on record that it is important for us to bear in mind that when we passed the Electronic Transactions Act, that was in 2011, the technology that we use for security and for e-signatures and protocols, that was something that was long since moved past because technology has gone a further way. Putting the regulations is critically important. Now, I heard Senator Saddam Hussein make a very curious observation that we were somehow interfering with the judiciary. I heard Senator Mark, in his usual conspiracy agitations, say that we were interfering with the judiciary and putting power into the hands of one office holder. I'd just like to simply refer Senator Mark to the Constitution of the Republic of Trinidad and Tobago. The Chief Justice runs the judiciary. What is this conspiracy theory that the Chief Justice should not run the judiciary? The Chief Justice is the person with responsibility administratively and legally to manage the affairs of the judiciary in a separation of powers arrangement. To harmonize the workflow that the judiciary manages through its divisions of court is entirely within the purpose of the legislation, as we seek to manage the magistracy registrar, the other workings, the removal of the clerk of the peace, the harmonization for the licensing committees, be it for cinematograph, liquor licensing, old metals, stores, theater, dance halls, whatever they may be, mental health. these things are a requirement for modification. I got a report of some of Senator Choate's submissions asking for data on the successes. Apparently, the message that came to me was that Senator Choate asked for a little more information on that. I think that the reply is a little bit too short for me to put on board what I certainly consider to be very significant reforms. Perhaps at the committee stage I can understand a little more of what Senator Choate was asking for so that I can address it in the context of the provisions of the bill. Madam President, I'd like to deal with this issue of the VAT bonds that Senator Diona-Ryan raised. My colleague, Senator West, spoke to the issues of the VAT bonds. It's true that the secondary transfers and secondary market, when they go to institutional hands, will not be inside the circle of the VAT arrangements. If you want to look at that, first you go to the persons who receive the VAT bonds. Secondly, there's a trading at the market. The rationale for the tax-free purpose was to improve the competitiveness of the secondary market. And if you could treat with the VAT bonds in that regard, you would not be asking people to take a haircut on the face value of the bond. And in those circumstances, we wanted to preserve the viability of the bond as in fact the market has recognized, because the market is accepting the bond at 100% of face value without a haircut on the face value of the instrument. And it's for that reason that we wanted to introduce the concept of tax-free concepts to interest, etc. But bear in mind, as the law continues to speak, because we're anchoring a provision into law, there may be derivative products or other products at a future point in time which could stand to benefit from the treatment of taxable or non-taxable treatments as we get into the structures. Senator Obika asked about the harmonized forms, the customs forms and pleasure craft. The Honorable Senator asked about why now. The reason is that there was an undertaking from the CSME perspective. In the CARICOM single market, we are obliged to have a consistency of approach. The forms that are required, Trinidad and Tobago is out of sync with the forms for the rest of the industry in the rest of the Caribbean, and therefore allowing for the ease of doing business to treat in the Caribbean context with pleasure craft the same way the rest of the CARICOM does. That's the rationale for treating with that as we do right now. Madam President, the reforms for the virtual court, for the requirements for persons to be visible to the court, those are de minimis requirements. I've noted Senator Thompson-Aye's recommendations that we allow for other persons to be present in the court. That is within the court's jurisdiction as it is. The person who comes in to lend assistance to the client who's there for moral or other kinds of support, which are obviously necessary factors, aren't necessarily persons who the court must see. That's the public hearing in the view that we look at it. What we're ensuring so that there's no witness intimidation and so that the court can see it, we're ensuring that the persons are described as the persons that must have camera view or pan view in the arrangements. I understand that Senator Choate raised some concern about the functionality of the virtual courts in the current COVID pandemic, indicating that the Court of Appeal may be working well, but that the High Court had certain issues that it had to solve. I accept that those are some of the reports that have come back to me in the function that I have, and that the judiciary has been taking its utmost best to ensure that we restart in full measure. As we get the final courts built out across at Tower D, you will note that the entire PAN arrangement for FTR, the technology that the Privy Council uses, for instance, in having full video imagery, that is going to be a feature that we will see, which ought to work out some of these issues in the virtual appearances that we're having at the courts right now. Madam President, I don't propose to address much more than that. I propose to address the rest of the considerations in the course of the committee. I will just remind honorable senators that we will be sitting tomorrow, so that there's no need for swan song just yet. I would end by telling Senator Mark, when he says he can't breathe and that he's tired, that surely retirement when he goes out of this parliament, as he goes into the winter of his existence, will allow him to breathe a little bit better. We accept that Senator Mark is tired and that Senator Mark needs assistance to breathe. Senator Mark can breathe all he wishes in the luxury of his retirement as he moves into that position very shortly. So, fear not, Senator Mark. Fear not, Senator Mark.
Senator Mark, please. Attorney General, perhaps you can wind up.
Winding up. I'm replying as well, Madam President. My friend likes to react too quickly. Fear not, Senator Mark. Your retirement is imminent and it will be permanent. I beg to move.
Members, please. There is levity, and then there's just taking something too far. We've reached that. But Senator Amin, I am speaking right now. Please, Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled the Miscellaneous Amendments Number 2 Bill.
Attorney General.
Sorry.
We're jumping the gun, so just give me the 4 words I need right now.
I did say I beg to move, sorry.
Honourable Senators, the question is that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Service Act, Chapter 601, the Evidence Act, Chapter 702, the Malicious Damage Act, Chapter 1106, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Service Orders Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commission, Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metal and Marine Stores Act, Chapter 8407, the Liquor Licenses Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, Chapter 20, Act 2011, the Criminal Division and District Criminal and Traffic Courts Act 2018, and the Electronic Payments Inter- and Out-of-Court Act, Chapter 2018, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Services Act, Chapter 601, the Malicious Damage Act, Chapter 1106, the Evidence Act, Chapter 702, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Services Order Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General's Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Election and Boundaries Commission Act, Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children's Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Moneylenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metals and Marine Stores Act, Chapter 8407, the Liquor License Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, 2011, the Criminal Division and District Criminal and Traffic Court Act, 2018, and the Electronic Payments into and Out of Court Act, Chapter Act 2018.
Attorney.
Thank you. First round seemed a little too easy, Madam President. Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled the Miscellaneous Amendments Number 2 Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that a bill entitled the Miscellaneous Amendments Number 2 Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honorable Senators, I remind everyone that there are 37 clauses in this bill. Each senator should be in possession of 4 sets of proposed amendments. Amendments have been circulated on behalf of Senator Thompson-Aye, Senator Wade Mark, Senator Anthony Vera, and the Attorney General. Yes, Senator Choate?
I do not have Senator Thompson-Aye's proposed amendments.
Senator Dinray?
Sorry. Madam President, I do not have a copy of Senator Mark's amendment.
Okay, so here's how we're going to do it. Does everyone have the Attorney General's? Anyone doesn't? Does everyone have Senator Vera's? Does anyone, right? So who does not have Senator Mark's? And who does not have Senator Thompson-Aye? Okay. Just 1 second, where's my bill?
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. There is a proposed amendment by Senator Thompson-Aye and Senator Mark. No, the Attorney General. And Senator Mark. So we'll start. Senator Thompson-Aye, can you speak to your amendment, please?
My amendment to clause 4 should follow F, video link, the definition of video link, and the parties who should be present. When we look at E, it says any other person who may be required to assist the court in the conduct of its proceedings. And I make this amendment, I'm proposing, in favor of perhaps what may be termed a vulnerable person who needs psychological or other support within the court system, but cannot be deemed as someone required to assist the court, but to just provide support and not to actually take part in the proceedings. So that I'm proposing any other person whom the court permits to be present. So permission will have to be sought from the court to have this person attend to assist the applicant or defendant or respondent.
And isn't there another element of your proposed amendment? At B?
Pardon me?
Isn't there an A and a B to your amendments, proposed amendments, Senator?
You want to deal with the whole 4? Oh, I see.
Yes.
All right.
Your proposed.
Now,
yes.
I see that after the word court, Section 21A, there appears to be a word missing there. As it stands, mark it there for me. As it reads, subject to rules made by the Rules Committee under Section 23 or under any other written law, the court may, such administrative fees as the Chief Justice may by order determine for costs associated with, continue. There's obviously a word missing there, and I propose that the word set. The court may set such administrative fees. The sentence is incomplete. So I'm asking for that word to be inserted there, the verb set.
Thank you. If I could deal with the latter one first. We also have circulated an amendment to use the word charge. So I agree with the Honourable Senator. Thank you for spotting the inadvertent error, which is the omission of the word, the operative word. Because we're dealing with court administrative fees, what we want to do is to charge a fee. So we propose that is charged, but that's taken up in the amendments that we have proposed that we have not yet come to. So if I may respectfully ask the Honourable Senator to consider that I have treated with it in another way, perhaps she may be willing to withdraw, but I'm not sure. With respect to the first part of the Honourable Senator's suggestion, we believe, Madam President, that we're talking about an amendment to the definition of video link as we have it in the Interpretation Act. It then finds itself into other parts of the bill, and we've considered what the Honourable Senator has said, but we believe that further persons to be within camera position is caught by E as in egg under the definition of video link, where we say any other person who may be required to assist the court in the conduct of its proceedings. I say that respectfully because whilst I do understand the emotional support aspect explanation that my colleague has offered, we're really talking about a limited space factor in the courtroom, and in the virtual hearings, the court really does determine who is required to assist the court in the conduct of its proceedings. That assistance also comes into, for instance, in any form of assistance. So I had the opportunity of an early circulation by Senator Thompson-Aye. I've raised it with the CPC's division to ask them their views. They respectfully believe that we ought to leave it the way it is as to subsection E allow matters.
I have here the manner in which cases are to be listed for hearing by a court and the parties who are to be notified. Again, I see the Attorney General has an amendment, but mine is better.
I'd just like to assure my honorable colleague that the CPC drafts these amendments for me, so I don't pretend to be passing myself off as the draftsman of this law. The CPC has recommended, Madam President, that we make the amendments as we have his recommendation, and in those circumstances, I believe Senator Thompson-Aye and I are capturing the same mischief, which is really to make sure that the wording reads correctly.
I haven't heard what he said, I'm sorry.
The Attorney General has basically said that both of you seem to be going along the same lines. So my question to you is, are you pursuing your amendment?
Oh, I'm pursuing my amendment.
Sure.
Because I think that word there is necessary. It's not
Sure. So, honorable senators, the question is that clause 5 be amended as circulated by Senator Thompson-Aye. Those in favor say aye. Those against say no. I think the noes have it. The amendment as proposed by Senator Thompson-Aye has not been accepted. Senator Mark?
Yes, my amendments are along the same lines of the previous amendment, where the Chief Justice seemed to have rather a lot of power. I am also seeing where the public service is being undermined in this amendment before us. And I'm also seeing, Madam Chair, that the whole concept of mediation is something that is being pursued in accordance with judicial discretion. I would have thought that such an approach as represented in 5F would represent a denial of the litigant to access justice. And what is going on in this section here, I do not know if the Attorney General could tell us whether mediation is going to be free and not be subject to a fee, and no fees, that is, would be imposed for mediation services. Because if that is the case, that would represent a denial of the litigant access to justice. And therefore, I was of the view that this question of mediation was a voluntary process and not forced upon parties or ordered by a court. So, Madam Chair, it's against that background, we are of the view that you have undermining of the public service, you have a repetition of the powers of the Chief Justice reoccurring, and then you have a situation where mediation is being imposed by the court, and we know there's a cost to mediation unless the Attorney General can tell us otherwise. So it's against this background, Madam Chair,
Sure.
that we are not in favor of the current amendment.
Senator Vera?
Just on the point of mediation, that when a court refers parties to mediation, that does not mean that the court has given up its rights or has abandoned the party's right to pursue their legal proceedings. What mediation does is it allows the parties to see if they could come up to an agreement that works for them. If they don't reach an agreement, and it's entirely a voluntary process, the matter goes back to court and continues. But for small claims, mediation makes perfect sense. And mediation also allows parties to come up with solutions that the court itself may not be able to impose. So it's better, this is a case of where it's good to have, better to have than to want.
Attorney General.
Perhaps I can assist Senator Mark in this difficulty, because when a court refers you to mediation, the very concept of mediation is that you must voluntarily agree to the process. You can't compel people to mediate. The essence of mediation is a voluntary agreement between the parties to engage A, in the process, and B, to see if they can find a solution. And I thank Senator Vera for clarifying the process. There is a court-annexed mediation aspect which the judiciary has promoted and which this government has underwritten in larger measure. In fact, I can tell you before the cabinet right now is an amplification of that. Litigation always costs. There's always a charge, there's always a fee. And I just simply reject the concept about denying people their freedoms, etc. That's just respectfully just not on, Madam President. So I don't associate myself with Senator Mark's comments.
Honorable Senators, the question is that Clause 5 be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The amendment as circulated by Senator Mark is therefore not accepted. Attorney General.
Madam Chair, Clause 5 we propose be amended as circulated in paragraph B, Roman 2, in the new subsection 1, capital B. Clearly the word of is inappropriate and should be for.
Senator Dylan Remy.
Madam Chair, how the revised, how the amendment is reads now still does not make sense, Attorney General. I think what Senator Thompson Ahi had proposed makes more sense. It says the manner in which the cases are to be listed for hearing by a court and parties are to be notified.
Perhaps I could explain. The chapeau, when married with subparagraph B, would read entirely like this. The Chief Justice may, by practice direction, give directions for the manner in which cases are to be listed for hearing by a court, and it means for the manner in which parties are to be notified. The two are read that way.
That's not there, you see.
So when you read the chapeau, which is the heading part, the Chief Justice may, by practice direction, give directions for. You continue at B, the manner in which cases are to be listed for hearing by a court, and then it is read from a drafting perspective as the manner in which parties are to be notified. So this is the CPC's construction, which is in keeping with the language as used in the rest of the Act.
Madam Chair, if we read the thing as a whole, the English doesn't read right. It just does not read right. So I don't know if you want to put that in our statute books, but I have a problem with English not reading right in the statute books of my country. I really do. If you read the entire thing through, you will see that it's deficient.
May I, Madam Chair? The CPC has leaned over to me to say emphatically that he does not agree with the proposal because we cannot use the word who as proposed by Senator Thompson-Ahi. I must defer to the CPC's construction of language as the drafter for Trinidad and Tobago. So I am in his hands as to how the law ought to be read in the context of the general positions. This is not meant to say that the English language is slightly different in its construct. I accept what the Honourable Senator is saying, but I must be guided by the CPC.
Sure. Senator Vera.
I'm wondering if commas might make a difference. So how it would read is the functions and duties of a senior magistrate registrar and a clerk of the court and a magistracy registrar and clerk of the court are
Vera,
to
Senator
J.
Vera, that's not where we are. So we are at page
I'm
15.
at 21. Okay, sorry.
All right. So the question is that clause 5 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 5 as amended now stands part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill. Senator Mark, you have an amendment.
Of course, thank you, Madam Chair. This, again, is perplexing, confusing. I can't understand it. Why all of a sudden the chief magistrate that is engaged in sentencing more than the High Court, 90% of sentencing takes place within the magistracy. That office holder is now a member of the Sentencing Commission or her representative. You have, for instance, a decision taken by the government, obviously in conjunction with the judiciary, in order to ensure that the Chief Justice or his representative would now be responsible for being members of this Sentencing Commission. But the Chief Justice, although he's in charge of the judiciary, he operates, or she, whoever, would have been there in the future, at the level of the High Court. And they are not in contact with the day-to-day activities at the level of the magistracy. That is why for years, since the Sentencing Commission came into existence, it was the Chief Magistrate that was there. So again, Madam President, out of the blues, you have this incursion, or let me withdraw that, decision, Madam President, to bring the CJ into this. And Madam President, we're not even too sure that the CJ is going to be here, because in the law, it is proposing a representative of the Chief Justice or the judiciary.
Madam Chair, I find it hard to just understand where Senator Mark is coming from. Perhaps I may assist this way. The judiciary is in lockstep with the Sentencing Commission. The Sentencing Commission existed on the books for nearly 2 decades, and nothing happened. It has finally been birthed, but it has come at a point in time after the full workings of the Judicial Education Institute, the JEI. The JEI has the task of significant review to harmonize the work product and to make sure that there's no incongruity between the magistracy and the judiciary. The recommendation is that the report of the Sentencing Commission goes to the judiciary, to the titular head of the judiciary, and then it is filtered through the judiciary in its judicial education and training functions. This allows for us to have a better harmonization of work product, and this is the rationale for this particular amendment.
Senator Vera.
Thank you. Just to put on the record that I spoke with the chairman of the Sentencing Commission on this point, and he said he has no problem at all with the amendment. The purpose of the reports are to make the recommendations concerning the administration of justice, and the Chief Justice is the best position to receive the reports.
The chairman of the Sentences Commission does not make law in this country. We make laws. So I don't take no direction from the chairman of the Sentencing Commission.
Senator Mark, because I really do believe that we should not treat persons who are not members of the chamber in a discourteous fashion. Senator Vera has indicated the position. I don't think that an antagonistic approach has to be taken to what the person has said.
11 person. So
As
I'm
am
not
I, Senator
antagonistic.
Mark, so will
So
you
no,
conclude?
the point
Yes?
I'm simply making
Yes?
is simply this. If what the Attorney General is saying, Madam Chair, why remove the Chief Magistrate? Leave the Chief Magistrate there. I don't see why they have to remove the Chief Magistrate.
Madam Chair, the extent of reform that we have engaged in may perplex people that don't pay attention at times. I mean that respectfully.
That reform is not in the interest
You know, I
of
don't
justice.
interrupt Senator Mark, you know, and he has a habit of doing it. Madam Chair, I mean no disrespect or discourtesy in what I've just said. I'm explaining it along the line. The reforms have come so fast that we have to harmonize these positions. I think that what I said is fairly clear. I respectfully disagree with Senator Mark's recommendation, but I do understand his agitations.
Honourable Senators, the question is that Clause 6 be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. I think the noes have it. The amendment as circulated by Senator Mark is not accepted. Honourable Senators, the question is that Clause 6 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clause 7.
The question is that Clause 7 stand part of the bill. Senator Mark?
Yes, Madam Chair. I listened to the Attorney General a short while ago when he spoke in his closing remarks, and he made reference to the SRC and removal of perks for MPs and so on. What he did not tell this Parliament, and as I get into this matter, is that a report came here. A report came here, and the Parliament took a decision to amend that report, and that is proper, Madam Chair. But in this instance, the Attorney General, for the second time in less than a year, has taken upon himself to take over the role of the Salaries Review Commission. He is now the new head of the Salaries Review Commission, and setting terms and conditions, Madam Chair, that ought to be done by the SRC. I have nothing against the RG. It could be the PG or the SG. It doesn't matter. I am dealing with principles here. And I'm saying, Madam Chair, a job evaluation must be conducted in order to determine if this office holder meets the criteria to become a chief legal officer, to be put on the same range as the Solicitor General. That is madness, Madam Chair. How can we sit here and unilaterally usurp the role and function of the SRC to deal with this thing? Madam President, I am a member of the Parliamentary Committee that is meeting with a team of consultants on improving parliamentarian terms and conditions. And we have to be putting forward our arguments so that they could form a proper job spec given the duties that we perform. That is part of a job evaluation exercise. So we have...
I'm sorry to interrupt my friend. Senator Mark is speaking to paragraph B, which he proposes no amendment. He's taken the time to circulate amendments. Clause 7, delete paragraphs C and D. Where is this coming from?
Senator Mark, I was about to ask that you speak to your amendment, which is to delete paragraphs C and D in clause 7. So C has to do with the senior magistracy, registrars, clerks of the court, etc. Correct? And D has to do with the, on page 22.
Yeah, so let's look at it in your. Dealing with C. C and D. Yeah. Believe that I should have incorporated in this 7, this 7(1)(c) as well, but I agree with what you were saying, that what is stated here,
Mark.
the entire 7 involve any terms and conditions of service of the Registrar General ought to have been included in my amendment. Because I'm of the view, Madam Chair, that this is a matter. Madam Chair, with your leave, can I ask you if I can incorporate it?
I think Senator Mark is saying in essence that he wants to delete all of 7. Is that correct? So delete clause 7.
Yes, thank you.
Right?
Yeah, so
and I think you've made your arguments in respect of what you are seeking. So, Attorney General.
Madam Chair, most regrettably, we can't agree to delete all of 7. It is critical, having abolished the sections to treat with the clerk of the peace and having created in law the senior magistracy registrar and clerk of the court, that we must make them ex officio justices of the peace and commissioners of oath, because they have legislative functions to fulfill and duties very much akin to what the registrar of the Supreme Court does. So to delete these powers would make a mockery of the structures that we use in creating ex officio justices of the peace and commissioners of oath. There is a need for them to be able to attend upon persons for those functions in the exercise of many laws which fall previously under the clerk of the peace and now under the registrar, if I can use that term loosely, for the magistracy. With respect to the terms and conditions of service for the Registrar General, Senator Mark is incorrect. The 98th report of the SRC, when laid in the Parliament, was not what caused the positions to be done. It was not in Parliament at all. It was by way of a cabinet decision. And that cabinet decision is what decided what happened. The report is always laid in the Parliament as it is.
Mark, let the Attorney General finish, please. Attorney General.
Madam Chair, I've had enough of Senator Mark, respectfully.
Attorney General,
I've had enough.
Let's continue, Attorney General.
See what I mean?
Senator Mark, please. Please. There is to be a certain order in these proceedings. Attorney General, just finish what you have to say, and then I will ask Senator Mark to respond, and then I will put it to the vote.
The submissions coming from Senator Mark for the deletion of Section 7 run contrary to the entire structure of law. it would be a sheer act of insanity to accept the recommendation for the deletion of subparagraph C, for instance, in 7. With respect to the provisions of the Registrar General, I've already addressed that in the debate. Suffice it to say that what Senator Mark informed this honourable committee is wrong as a matter of fact and position. In those circumstances, I respectfully reject Senator Mark's recommendation.
We reject completely the Attorney General's submission. I was in that chair, and I know what went on in this Parliament with that report. He was somewhere else. So he cannot tell me.
No, well, first of all, Senator Mark, you're referring to the Attorney General.
With greatest respect. So I reject completely, out of hand, what he has said.
So
Madam President, let me just go on to my point, Madam Chair. Yeah. Madam Chair, may I also ask the Attorney General, what is the rationale for the senior magistracy registrar and the clerk of the court reporting directly to the Chief Justice when they are supposed to be under the jurisdiction of the Chief Magistrate? Why go to the Chief Justice to report, Madam Chair? And then, Madam Chair, remember, these people are also responsible and they play a big role in the licensing committee. So the Chief Justice is also involved indirectly and directly at times with the licensing committee. So I would like him to explain, that is the Honorable Attorney General, why these persons have to report directly to the Chief Justice and not to the Chief Magistrate. That's all.
Attorney General.
I'm most respectfully very sorry. I just didn't hear anything of what Senator Mark just said.
Senator Mark is asking, why do these persons in these positions have to report to the Chief Justice and not to the Chief Magistrate?
The line of authority for reporting in the streamlining that happens with the new divisions of court is that you report to the Chief Justice, and then the Chief Justice, through the administration of justice side of the equation, via court executive administrator, court officer, etc. That's the way it is done. It is to harmonize the High Court with the magistracy. I'll just like to remind that we have merged the jurisdictions in the magistracy and in the High Court. And if I could just simply underwrite that by referring to the fact that we have in fact amended the definition of magistrates. They're now judges of that court. So it is to harmonize the entire judiciary.
Senator Vera.
Also, just to point out that this is an amendment that is being made under the Judicial and Legal Services Act. So and this is an amendment dealing with 15. What 15 is saying is that subject to the Constitution and to any written law, control and supervision may be exercised over. So all of these things are not under just the Chief Justice. They may be a reporting chain, but the supervisory body is really the Judicial and Legal Services Commission.
So, Honourable Senators, the question is that Clause 7 be amended as circulated by Senator Mark and further amended to read delete Clause 7. Those in favour say aye. Those against say no. I think the noes have it. The amendment as proposed by Senator Mark has not been accepted. Attorney General, you have an amendment?
Yes, Madam Chair, and forgive me, I've also spotted that we need to further amend the amendment that I've circulated. So perhaps you could bear with me if I were to explain the wording that I'd like you to adjust. Is that okay?
Yes.
Thank you, Madam Chair. Madam Chair, you'll see that in Clause 7, we're proposing beginning in paragraph C. Regrettably, I had omitted amendments to paragraphs A and B. May I indicate those now?
Sure.
So it'll be 3 parts then for the amendments for section 7, clause 7. In the first part, we would say in paragraph A, delete, in paragraph A, in brackets, delete, open quotations, subsection, open brackets, 1, close brackets, inverted commas, So we're deleting subsection 1. And substitute, open quotations, section 15, open brackets, 1, close brackets, close quotations.
And substitute, open bracket, section 15.
Section 15, 1. So the 1 is in brackets.
Right, okay.
Yes?
Close
quotations. And then we'll say in paragraph B, and we'll repeat exactly the same words as we just said. Delete, open quotes, subsection 1 in brackets, close quotes, and substitute section 15, 1B, capital B, forgive me. So it'll be capital B. Yes, so we're deleting subsection 1B, and we're replacing with, we're substituting section 15, 1B. May I speak to the reasons now?
Yes, Attorney General.
Much obliged. So, Madam Chair, we are proposing these amendments effectively to make cross-reference fix to the subsection as we had in A and B. They wouldn't have made sense if we didn't refer them back to the proper Parent Act positions, which is section 15.1 and section 15.1b. We are in the version that has been circulated. Because we have allowed for the referral of parties to mediation, we needed in 15C, subparagraph J as in Juliet, to include the referral of parties to mediation. And therefore, it is to just harmonize the amendments that we've done previously into this particular section.
So, Honorable Senators, the question is the clause 7 be amended as circulated by the Attorney General and further amended as follows. In paragraph A, delete subsection 1 and substitute section 15.1. In paragraph B, delete subsection 1B and substitute section 15.1b. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 7 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 as amended now stands part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill. The question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that clause 9 stand part of the bill. Senator Mark.
Madam Chair, the Rules Committee, from where I sit, how this is to be interpreted is that the Rules Committee will now be making rules prescribing any matter of procedure that is necessary or expedient for the purposes of this act. Madam Chair, I interpret this to mean that the Rules Committee will now be making rules for the magistrates' court when in the past it used to be confined to making rules for the High Court and the other areas of that environment. Now, if they are going to make rules for the magistracy, Madam Chair, I would like to get some clarification as to whether magistrates, particularly chief magistrate, would be a member of the Rules Committee, or whether the Rules Committee will only be comprised of the normal persons at the level of the Supreme Court who would sit on it.
Senator Mark, we are on clause 9, right?
Yeah, is that the malicious?
Yes, the Malicious Damage Act, which
Yes,
is being amended.
Yeah, but is Amendment 51,
Sure.
the Rules Committee?
Okay. Attorney General.
Madam Chair, just respectfully, nothing of what Senator Mark just made any sense to me.
Nothing about what Senator Mark is proposing is, yes.
Sorry, I'm getting to it. I'm trying to get over my exasperation and taking my time to say it.
And I'm trying to take you over that exasperation so that we can move on as well.
Thank you, Madam Chair. I sincerely appreciate it. Madam Chair, we are providing for the Chief Justice pursuant to the rulemaking function in the judicial arrangements that we have had since prior to independence to make rules with respect to procedure. That's what the Rules Committee is for. We produce those rules. They are subject to negative resolution, and therefore I just don't understand respectfully the submission coming from Senator Mark.
So, Honourable Senators, the question is that Clause 9 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no.
No.
The amendment of Senator Mark has not been accepted. The question is that Clause 9 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill. The question is that Clause 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that Clause 11 stand part of the bill. Senator Mark.
Yes. Madam Chair, I went through the Hansard when this matter was debated, and I saw where the Attorney General was. I look at 128, page 128 of our debate on the SSC report on sexual offences amendment bill for adoption, dated the 6th of June 2019. And Madam Chair, if you would allow me to just share with this honourable committee through you what the Attorney General said. We also believe that Clause 67 needs to be amended more, I want you to emphasize, more than the manner in which Senator Mark recommends. My friend is very close to Wade Mark. He goes on. In Clause 67, but in Clause 67, we notice there was no way to amend the second schedule other than by way of an act of Parliament. So we propose that the second schedule be amended in the same way that we do the first schedule. That is, by way of affirmative resolution of the Parliament. Now, Madam Chair, the reason why I quoted this is to bring to your attention that the Attorney General recognized that because fundamental rights and freedoms are involved in these schedules, that if you go to amend Schedule 1 and 2, you will have to create a new act. And that is why we had to go the route of an affirmative resolution. That is what the Attorney General said in this debate. And I did not even propose an affirmative for the second schedule. It was the Attorney General who did that. So, Madam Chair, it is clear that fundamental human rights are involved in this matter. And for the Attorney General to come here and tell us that we must back from this affirmative to a negative is absolutely unacceptable. This matter will be challenged in the courts of Trinidad and Tobago.
Attorney General.
Thank you, Madam Chair. Thank you, Madam Chair. Regrettably, Senator Marcus only read piece of my contribution, because I then went on to specifically say that we would propose in a miscellaneous provisions bill that we remove the position from affirmative resolution to negative resolution when we came and we spent an entire occasion in Parliament to amend the schedule by way of an affirmative resolution process. In those, you see, Madam Chair.
Senator Mark, I know, but the Attorney General is making his contribution now. Can we please listen to him in silence? Thank you.
So, Madam Chair, the position is, I don't know what fundamental rights Senator Mark is referring to. We're referring to offenses listed in the schedule of the Sexual Offences Act. There's no fundamental right in an offense being listed in a schedule. What is important is that there is a parliamentary oversight of the mechanism by which the schedule is amended. That, Madam President, quite simply put, is by way of negative resolution. It's laid in the Parliament, the order. You have 42 days to negative the position, and there is well-established precedent for that. In the consultation that we took on this particular position, the recommendation coming from the wide range of stakeholders in the practice, etc., is that this ought to be done by way of negative resolution.
Senator Mark?
May I ask respectfully, because I myself have to exercise great patience with what I'm hearing here today from the lips of the Attorney General. Can the Attorney General point out to this Senate what page of his contribution that he referred to when he said he's going to come back here with a negative resolution to fix this? Could he do that? I quoted what he said. Let him quote for us where he said that, on what page. And while he's thinking, because it's very hard to come up with it, let me indicate to you, Madam Chair, the following. The specific removal of this procedural protection and our oversight mechanism is disproportionate in that it fails certain limbs of the proportionality test, and it does not pass that test, Madam President. And therefore, this matter is a very serious matter because it can render the entire registration process unconstitutional and non-compliant with Section 13 of this Act. That is why I told the Honorable Attorney General, sure, if he doesn't get it right, that will be dealt with elsewhere.
Attorney General.
Well, I don't know about Section 13 of that Act. That's certainly not on. That's just not what it is.
Senator Mark.
Sorry, Madam.
Let that be the last time, please.
I apologize to you.
Attorney General.
Madam Chair, most respectfully, Senator Mark is referred to my entire contribution when we debated the amendment to the schedule, which we brought by way of a separate act. We spent an entire day in the Parliament. In my presentation and in my wind-up and at the committee stage, I repeatedly made reference to the need to amend the law by way of negative resolution. It's there on the Hansard.
So, Honourable Senators, the question is that Clause 11 be amended as circulated by Senator Mark. Those in favour say aye.
Aye, Madam President.
Those against say no. The amendment as proposed by Senator Mark has not been accepted. The question is that Clause 11 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 11 now stands part of the bill.
Clauses 12 to 16.
The question is that clauses 12 to 16 stand part of the bill. Yes, Senator Thompson-Aye.
The Attorney General, through you, be minded to include in commas, two particular clauses, 6 and 9. Would it be
Senator
in
Thompson,
mind without a written?
wait, just 1 second. We are now dealing with clauses 12 to 16. So, Honourable Senators, the question is that clauses 12 to 16 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 12 to 16 now stand part of the bill.
Clause 17.
The question is that clause 17 stand part of the bill. Attorney General, you have a proposed amendment.
Yes, Madam Chair. Madam Chair, the recommendation contained in the bill, unfortunately, was something that we had not got right when we first passed the bill. We're seeking in clause 17 here to allow for a bit more flexibility as we move to an online presence and as we move to the better functionality of the Registrar General's offices. We think it unduly prescriptive to set out the days on which the registry will be closed in parent law. So, for example, the public holiday following Easter, that is something that really ought not to occupy parent legislation prescription. Instead, we propose that the minister with responsibility for legal affairs may, by order, amend the days specified in subsection 1. This is in keeping with the amendments that we've done to the judiciary's time and days of operation to allow it to be done by way of order, and that we can have some flexibility as we move as a society forward.
Honourable Senators, the question is that clause 17 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 17 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 17 as amended now stands part of the bill.
Clauses 18 to 22.
The question is that clauses 18 to 22 stand part of the bill. The question is that clauses 18 to 22 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 18 to 22 now stand part of the bill.
Clause 23.
The question is that clause 23 stand part of the bill. Senator Mark, you have an amendment.
It's most appropriate that we are dealing with psychiatric matters. Madam Chair, again, I am not defending anyone. I'm dealing with principle. And I'm asking the question, Madam Chair. In the current scenario, the Mental Health Act, we have the chief magistrate or her designate who sits on what is called the psychiatric hospital tribunal. What the Attorney General is advancing is to have the chief magistrate or her designate replaced, not by the Chief Justice, but by a representative of the judiciary appointed by the Chief Justice. Madam Chair, I am very concerned. This is another step in a confusing puzzle that is aimed at undermining the role and functions of the Chief Magistrate. Why? I don't know. I can't say. And therefore, Madam Chair, we are not even too sure that this representative of the judiciary appointed by the Chief Justice, whether that person would be a non-judicial person sitting to decide matters under Section 18 of the Mental Health Act as it relates to admitting persons to a mental hospital, which, as you know, Madam Chair, may be done by a judge or a magistrate under Section 13 of the Act. So again, it's a widening of the power of the Chief Justice without no good reason being advanced. So I need to get some answers from the Attorney General, who is piloting this matter on behalf of the Chief Justice.
Attorney General.
Perhaps I may assist Senator Mark. Number one is that we have removed several magisterial districts and harmonized them into 3. We now have Tobago, we have North Trinidad, and we have South Trinidad. Secondly, Madam Chair, we have merged the jurisdictions between the High Court and the Summary Court. And now that we have case management, including masters as well, depending upon the division that you come, it is therefore not certain that one may in fact be before the magistracy at any one point in time as opposed to the High Court. A further reason is that in the judicial structure and training, the Chief Justice obviously receives the reports of the Chief Magistrate. The Chief Magistrate is someone who reports to the Chief Justice. So there's no dilution of the Chief Magistrate's function, because the Chief Magistrate, who is now going to be the Chief Judge in the Summary Court jurisdiction, still reports to the Chief Justice. All that this allows in the amplification of the judiciary's purpose is for better harmonization of judicial output, so that the training and structures and persons that have the time in the compositions of teams set out by the judiciary will have the best offer there. So there is no intrusion or dilution of the magistracy in any form or fashion.
May I ask whether the Chief Magistrate was consulted on this matter?
I really couldn't tell you. That's not my function.
Oh, no, it may not be your function, but you seem to be totally and intimately involved in what's going on here.
Madam
so
Chair,
you ought to know what's going on.
Senator Mark, Attorney General, there's no need to respond to that. I will now put the question. The question is, Honourable Senators, the question is that Clause 23 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The noes have it. The amendment as proposed by Senator Mark is not accepted. Honourable Senators, the question is that Clause 23 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 23 now stands part of the bill.
Clauses 24 and 25.
The question is that clauses 24 and 25 stand part of the bill. The question is that clauses 24 and 25 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 24 and 25 now stand part of the bill.
Clause 26.
The question is that clause 26 stand part of the bill. Senator Vera.
Chair, well, my amendment proposes an expansion of the committee from 10 to 12. It will be 13 instead of 11 because the conservator of forests will be an ex officio. And the other two I am proposing to add would be at E, a member drawn from the following disciplines or group: environmental science and land use science. Now, I had originally suggested veterinarians, but there's a zoological society there, animal health and welfare is there, wildlife conservation is there. And since wildlife is all about forests, I think land use science would be critical and environmental science. So those are my recommendations.
Well, before I call on the Attorney General to respond, Senator Vera, may I just commend you on the amendments in terms of how you have set them out, not on the substance, but on how you have set them out today. Yes? Attorney General.
I fear I'm getting involved in other people's business, but Madam Chair, Madam Chair, I was hoping,
Well, Senator Vera, you remember on the last occasion? Yes. Yes. Okay. So obviously just one person has listened to me in this entire chamber.
Madam Chair, I was hoping my colleague Senator Rambarat would be back because this is his proverbial baby. I have absolutely no objection. I know Senator Rambarat indicated in his contribution that he welcomed the amendments. I'm just at a small disadvantage whilst he's out.
So is Minister of Agriculture to read? Okay. So I will stand down deliberations on clause 26.
Clauses 27 to 34.
The question is that clauses 27 to 34 stand part of the bill. Senator Dana Ryan.
Thank you, Madam Chair. No, I do not have an amendment to the amendments, but however, I would like to seek some clarification based on the response that I would have received on the points that I raised in my debate. Now, the Honorable Attorney General did say that...
Which clause?
Clause 27, my apologies,
yes.
with respect to the VAT bonds. The Attorney General did say that the VAT bonds, the initial holders of the VAT bonds would indeed be tax exempt in terms of the interest that is being paid on the bonds. And however, when it goes towards trading in the secondary market, the bonds would, however, be subjected to taxes. Is that correct?
Sorry, Madam Chair, I didn't quite say that. Forgive me if I wasn't clear in expressing myself. So, first of all, the amendment in clause 27 is intended to speak forever. Not necessarily on this bond, but any future bond. And what we wanted to do is to preserve the legal option to have taxable or non-taxable bonds. With respect to the particular bond that is in circulation now for VAT payments, these bonds we wish to treat with in a non-taxable way, and specifically, therefore, we'll have to amend the regulations for that purpose which have been produced so far. However, there will not be, as far as I understand it, and here's where I will welcome my colleague Senator West to join the equation, as this falls squarely within her portfolio. There is not, so far as I understand it, any intention to say that the second holder will be taxed as opposed to the primary holder. That would be to discriminate in law on the nature of the bond, which is not possible. So if they're non-taxable, they're going to be non-taxable. If we said the primary person was non-taxable and then the secondary holder was taxable, well, then you'd be inviting not only confusion in the marketplace, but you'd also be inviting for a discount on the face value of the instrument.
Sure that they are transferable so that the people to whom refunds are due can easily encash the bonds. And we enhance that position by ensuring that the persons to whom the bonds are transferred also enjoy the benefit of the tax exemption. And that allows them to purchase the bond at full face value as opposed to at a discount.
Okay, thank you, both ministers. Madam Chair, my question then is, what then is the justification for subjecting these bonds to tax in the first place? I don't understand the logic in doing that, given that it is a reimbursement to tax liability.
Well, remember the bond bears interest, so it's not the bond itself that will attract the taxes. The interest falls within the definition of income, and all income is taxable unless it's specifically exempted.
Madam Chair, it's to allow for the benefit which otherwise would kick in by way of taxation. So right now, unless you make it non-taxable, it's going to be taxed. So this is to specifically contemplate the relief for taxation, and to do that, you have to be expressed in the law. And to be expressed in the law, meaning the regulations which govern the bonds, the parent law must permit the opportunity to do that. So that's why we're doing that.
Okay, and I assume all of this would be prescribed in the regulations?
They would have to be prescribed in the regulations. So the parent law creates the springboard from which the bond is created, and the regulations prescribe the terms and conditions for the bond.
Okay, thank you. Madam Chair, last question that I want to raise. I made a suggestion during my contribution in terms of the consideration in the future to allow for the option for persons who are owed taxes to select either a cash option or a bond option. Would that be consideration in the future? Could that be considered?
That is something that you raised, yes, but that is beyond the scope of this committee at this stage, yeah?
Okay, thank
Senator
you.
Mark, you wanted to raise some issue?
Madam, I don't have a, Madam Chair, that is, I don't have an amendment, but through you, to the distinguished Attorney General, I seek clarification on section, or I should say clause 28, Madam Chair. Madam Chair, first of all, I would like the Attorney General to refer to regulation number 40 under the Customs Act to ensure that the definition that is used in the present bill is consistent with that in regulation 40. There appears to be some variation, and I think that we need to be consistent. So I ask the Attorney General, before we go forward, to look at regulation 40 of the Customs Act. The second area I would like some clarification on is this. Why are we exempting pleasure craft from being inspected for cargo? Because pleasure craft would leave here, go Barbados, Grenada, St. Vincent, all of the islands. And Madam Chair, they may even reach as far as Miami. When they return to these territorial waters, they would have things on them. Why are we saying that we are exempting them as compared to a commercial ship or craft? I think that is needed because right now they seem to be under the surveillance of the customs body. And the final area for clarification is this. Why are we replacing a public servant that is insulated from the politician to deal with this matter of the issuing of forms, prescribed forms, as it relates to those people who are coming in here with pleasure craft, and they have to fill out these forms? What has led to this decision to remove the Comptroller of Customs and Excise, who has been doing this since 1930, Madam President? That is almost 90 years, going to 100 years. Why are we removing that under Section 264 of the Customs Act and putting a politician in the persona of the Minister of Finance? I know you stopped me this morning when I went a certain way.
Is that it, Senator Mark?
Yeah, those are the three areas I would like to have some clarification on,
Attorney
because
General,
it is not reading well.
Attorney General, do you have no? Yes, you've gotten all that Senator Mark has raised?
Sure.
Sure.
But AG, most importantly, the regulation 40, I think that's the most important one.
Senator Mark, let's let the Attorney General answer.
Thank you, Madam Chair. Let's deal with the last one first. The reason that we're using the minister as opposed to the Controller of Customs is specifically because it's going to be a tripartite relationship to cause the harmonized forms. The Minister of Health, the Minister of Trade, the Minister of Finance. If we were to include the Controller of Customs in the place of the Minister of Finance, we'd not be able to get the forms done in a post-1976 constitutional arrangement. So the Customs Act is a saved law provision. The Controller has certain quasi-judicial and other functions under the saved law, which would not prevail in today's world. To get the harmonized forms done, Minister of Health, Minister of Trade, Minister of Finance, etc., these three entities have to coordinate. So that's the reason why we're putting the minister in this particular equation. With respect to the harmonized forms for pleasure craft, we're not exempting pleasure craft. We're just putting a different form for the pleasure craft to use, a more user-friendly arrangement. So they will still be subjected to interdiction, to inspection, etc. It's just a different form that we're using. With respect to the Regulation 40, if I could just ask for clarification, which aspect of the definition causes Senator Mark concern?
No, I don't have a copy of it before me, but I'm advised that there ought to be some consistency between the definition that we have in the legislation and Regulation 40. That's why I ask you if you can look at Regulation 40 to see if there's any inconsistency with the definition, because you always promote the concept of harmony. So we want harmony, and that is why I ask you to look at Regulation 40. That's all.
That helps me. Thank you, Senator Mark, through you, Madam Chair. Fortunately, regulations are subsidiary in nature, and what we need to speak to, therefore, is the primary law. Everything else is harmonized ex post facto, so that we can fix the regulations if there is indeed an inconsistency, because I haven't found Regulation 40 as yet, but that can easily be sorted out by way of adjustment to the regulations if there's a need to.
So, Honourable Senators, the question is that clauses 27 to 34 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 27 to 34 now stand part of the bill.
Clause 26 revisited.
The question is that clause 26 stand part of the bill. Attorney General, your response to Senator Vera's proposed amendment.
May I defer to Senator Rambarat, please?
Minister.
Thank you, Madam Chair. Madam Chair, in relation to the proposal for 26E2E, the change in the number is acceptable. I had mentioned that in my contribution. And environmental science is fine. And Senator Vera, you had mentioned the vets. So now you have included land use science. Is that?
When I looked at the number of people who were representing animal zoological, animal health and welfare,
right.
Well, I thought they had enough animals.
Fair enough.
So these were, because I know what you're looking for is a broad set of competencies on the committee. So I thought that these were more applicable. Land use in particular would deal with protected area management and of course environmental science.
Would the land use planning be better? Land use planning is actually the profession, land use planning.
Yes. Well, land use would be, if you want to put, well, deals with broader landscape management, protected area management.
No, but I see the word science there, land use science.
Land use science, so that is the whole science, yes.
Because what happens when these things go to cabinet and it goes for checking at the AG's office, sometimes you have public servants who look for a perfect fit to the description. So at the university, there is a program in land use planning.
Okay.
I got it that Senator Vera was trying to capture things like environmental sciences, etc., as opposed to planning. I'm not quite sure if that's what the Honourable Senator was pushing at.
No, but there's a specific... Roman 6 is environmental science, but Roman 7 is land use science, and I'm just asking if it would be best captured using land use planning instead of land use science.
I hear you, Minister. I just checked it. Land use science is necessarily an interdisciplinary science since land use is influenced by and influence environmental, ecological, social, and economic systems through a complex series of natural and socioeconomic processes, including management and decision making. And that's from the Journal of Land Use Science. So,
right, and you believe that we'll have a sufficient pool of land use scientists in Trinidad and Tobago to draw on?
If you have?
A sufficient pool, a sizable pool.
Well, I would think coming out from the same land use development plan, yes, because land use is critical with forests and roads and all of that.
Right.
And one other point, Minister, if I may, where you have wildlife conservation, I think technical phrase that is preferred now is biodiversity conservation.
While
What-
Biodiversity.
Biodiversity conservation instead of wildlife. And community service, I'm wondering if community development might be more apt. Those are my only suggestions.
I have no problem with all those suggestions. Thank you.
Madam Chair, let me just come in here and support Senator Rambarat's claim of land use science. What happens in the setting of these committees? I'm not blaming public sermons so much, but you may not find somebody with a degree in land use science. These are very rare courses that some innocuous university somewhere around the world may give. Whereas you may have our university here and those in the United States and in England. So land use planning is really covered in lots more university, and it takes into consideration most of the aspects of the land use science as you so define. So I crave your indulgence in agreeing with the Honorable Minister of Agriculture and Lands.
I am comfortable with it. I'm guided.
Yeah.
So, Attorney General, is it that
So, Madam Chair, I heard a wonderful discussion which requires further amendment.
Yes, that's what I was going to ask. So we have the amendment as proposed by Senator Vera, but I heard something else. I think in E12, is it something that you're going to add there, Minister?
Instead of two further proposals. One is where we have wildlife conservation, to replace it with wildlife diversity, biodiversity conservation, which is acceptable. And the other one is where we have community service, which is
At 4.
at 4,
Yeah.
which to use community development, and that is also acceptable.
Okay. So, Honourable Senators, the question is that Clause 26 be amended as circulated by Senator Vera and further amended as follows on page 38E2. It will now read biodiversity conservation. And at 4, it will read community development instead of community service.
Yeah.
Those in favor say aye.
If you don't forget to change sciences as circulated by Senator Vera to
Yes.
planning.
Yes, that's correct.
Thanks.
So let me do it over. The question is that Clause 26 be amended as circulated by Senator Vera and further amended as follows. At Clause 26E2, on the circulated amendment, instead of the word science, substitute the word planning. And then at page 38, at E2, instead of reading wildlife conservation, it will be biodiversity conservation. And at E4, instead of community service, it will read community development. Yes. Those in favor say aye. Those against say no. I think the ayes have it. The question is that Clause 26 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 26 as amended now stands part of the bill.
Clause 35.
The question is that Clause 35 stand part of the bill. Senator Thompson-Aye, that you have circulated an amendment.
In favor would be the same as for Clause 4. The Attorney General counter-arguments would be the same. Why to persist, it would be an exercise in futility. In the circumstances, I withdraw.
So the amendment is withdrawn, the proposed amendment. So the question is that Clause 35 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 35 now stands part of the bill.
Clause 36.
The question is that Clause 36 stand part of the bill. Senator Mark, you have an amendment.
Yes, Madam Chair. It seems that the reforms that have taken place in the judiciary was designed specifically to oust some people. I am seeking to have this clause deleted, Madam Chair, because again, this clause seeks to replace the Chief Magistrate with the Chief Justice. And therefore, according to the Attorney General, Senior Magistracy Registrar and the Clerk of the Court must report directly to the Chief Justice. And Madam Chair, it is another example from where I sit, where this proposal is seeking to undermine the authority of the Chief Magistrate who presides over these courts and rests the sole control in the hands of the Chief Justice. And Madam President, the Attorney General, in his limited intervention earlier today, offered no rationale or proper reason for this development. And if I may say finally, it appears that the Chief Justice, given what is being proposed here, is again being given the opportunity to extend his powers and supervisory control over the magistrate's court, and in the process eroding the authority of the Chief Magistrate. So on that basis, Madam Chair, I am calling for the deletion of this provision.
Attorney General.
Thank you, Madam Chair. Well, this clause has nothing to do with anything of what Senator Mark just said. Absolutely and completely nothing. This clause proposes that in any written law, magistrate shall be referred to effectively as a district court judge. I don't know where Senator Mark gets this whole reference of Chief Justice replacing magistrate, etc. That's just not on. I have no idea where that comes from. And then further we go on to say a clerk of the court shall be in reference to a senior magistracy, etc. So perhaps Senator Mark is reading something else, but there is nothing of the line, reason, function, or methodology discussed by the Honourable Senator, and this is a very straightforward clause to make sure that the terminology is precise.
So, Honourable Senators, the question is that Clause 36 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The noes have it. The amendment as proposed by Senator Mark is not accepted. Honourable Senators, the question is that Clause 36 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 36 now stands part of the bill.
Clause 37.
The question is that Clause 37 stand part of the bill. Senator Dylan Remy.
Senator Choate, during her contribution, had mentioned that the Electronic Payments Act in Section 14.2 did not have what was recorded here in the amendment.
Sorry, I can't hear the Honourable Senator.
Senator Dylan Remy, can you speak up a little bit so that we can hear you?
The Electronic Payments into and out of Court Act sections. Sorry. Senator Choate? Shall I go ahead? It was based on your contribution. You were saying that that part of the bill, so I was just picking it up as it wasn't mentioned. Madam Chair, the electronic payment into and out of court, Section 14.2 says the court executive administrator may issue the cause or cause to be issued a prepaid card to be used for the electronic payment of fees. And there's nothing here that talks about and the chapeau says, doesn't have anything that is recorded in the bill here, in the amendment.
Okay, Attorney General.
Yes, I understand exactly what the Honorable Senator is referring to, and perhaps I could clarify. So Act number 14 of 2018 did not have this. We amended, this Parliament amended Act number 14 of 2018 by Act number 19 of 2018, and that's where the words come in. And now we're amending that number 19 of 2018. I understand that obviously we don't have the laws yet all brought up to speed to show what the current amendments are, but we did take a look, Senator Choate and Senator Dillon. What we're amending is the amendments to that law that we caused by Act number 19 of 2018 and not as it appeared in number 14 of 2018.
Thank you. Sorry, Madam Chair. Thank you. I just couldn't find it, not even on the Parliament website.
Senator Dillon Remy.
Instead of Act 14?
No. So what happened is 19 amended 14. So when we're amending 14, it is as has been amended. Okay. So we go back to the original act, which is number 14. Normally these things would become chapter X of Y. But until number 14 of 2019 becomes a chapter of the laws of Trinidad and Tobago, we still refer to it that way. So if you look to the previous clause, where we amended the criminal division, we call it number 12 of 2018. And if you look importantly to the one just before that, the Administration of Justice Indictable Proceedings Act, in the marginal note you'll see number 20 of 2011. This Parliament, we have amended that 3 times since then. So all of the amendments backfill into the pot of the original act, and that's why we make the marginal note reference back to the original act.
Okay.
So, Honourable Senators, the question is that Clause 37 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Clause 37 now stands part of the bill. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Thank you, Madam President. I wish to report that the Miscellaneous Amendments Number 2 Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on the Miscellaneous Amendments Number 2 Bill 2020. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Services Act, Chapter 601, the Evidence Act, Chapter 702, the Malicious Damage Act, Chapter 1106, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Service Orders Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dancehall Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commission Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children's Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metal and Marine Stores Act, Chapter 8407, the Liquor Licensing Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, 2011, the Criminal Division and District Criminal and Traffic Courts Act 2018, and the Electronic Payments into and Out of Court Act 2018, and the be read a third time and pass.
Honourable Senators, the question is that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Service Act, Chapter 601, the Evidence Act, Chapter 702, the Malicious Damages Act, Chapter 1106, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1401. Am I right in that? Chapter 1201, the Community Service Orders, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registration of the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commission, Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Motor Vehicle and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Money Lenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metal and Marine Stores Act, Chapter 8407, the Liquor Licenses Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act 2011, the Criminal Division and District Criminal and Traffic Courts Act 2018, and the Electronic Payments into and Out of Court Act 2018 be now read a third time and passed. Those in favor say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Summary Courts Act, Chapter 420, the Petty Civil Courts Act, Chapter 421, the Sentencing Commission Act, Chapter 432, the Judicial and Legal Service Act, Chapter 601, the Malicious Damage Act, Chapter 1106, the Evidence Act, Chapter 702, the Coinage Offences Act, Chapter 1115, the Sexual Offences Act, Chapter 1128, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Community Service Orders Act, Chapter 1306, the Defence Act, Chapter 1401, the Firearms Act, Chapter 1601, the Explosives Act, Chapter 1602, the Registrar General Act, Chapter 1903, the Cinematograph Act, Chapter 2010, the Registration of Clubs Act, Chapter 2101, the Theatres and Dance Halls Act, Chapter 2103, the Electronic Transactions Act, Chapter 2205, the Elections and Boundaries Commission, Local Government and Tobago House of Assembly Act, Chapter 2550, the Mental Health Act, Chapter 2802, the Children Act, Chapter 4601, the Motor Vehicles and Road Traffic Act, Chapter 4850, the Conservation of Wildlife Act, Chapter 6701, the Value Added Tax Act, Chapter 7506, the Customs Act, Chapter 7801, the Companies Act, Chapter 8101, the Moneylenders Act, Chapter 8404, the Pawnbrokers Act, Chapter 8405, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Old Metals and Marine Stores Act, Chapter 8407, the Liquor Licenses Act, Chapter 8410, the Administration of Justice Indictable Proceedings Act, 2011, the Criminal Division and District Criminal and Traffic Courts Act, 2018, and the Electronic Payments Into and Out of Court Act, 2018.
Honorable Senators, at this juncture, the sitting will be suspended and we will return at 10 minutes to 6.